Dictation.
You know, dictated, signed everything. You know it, Mr. Huh?
In terms of not.
No.
That is not applied.
It is not applied. That judgment has not been made applicable. You haven't seen the order. Please don't do it. Don't do it, Mr. At least go through the order. Now start drafting SLP. Oh, yes, yesterday you were very keen to argue. A client is called.
You said
We don't know. No, this is unfortunate, Mr. That without going through the order, you are making submission. This is what we don't want to begin our day with cost, but I think 25,000 rupees is more than just. No, I mean, this is what is this? Unfortunate. What? What is it, Mr.? You should screen. Mr. What is it? Settlement. Tomorrow. Fine, tomorrow. That withdrawal today. Right? Next. Yes. Tomorrow, let it be tomorrow. Yes.
2 weeks, file the application to bring the LRs of the deceased respondent number 2 million, 4 million. I will remove the defects.
10 years, Mr. Achari.
I have filed application to the LRs of the deceased respondent number 4.
2 weeks preemptory.
That's respondent number. They are served.
Respondent number 4 million.
They are served. Respondent 4 AC. Who is respondent 4? Huh?
Served.
Already served. We'll allow the.
Heard on IA 1 of 22. For reasons assigned in the application duly supported. IA 1 of 2022 is allowed.
Respondent 4A to C. They are served. The cost
Let
is
amended cost title be filed within 1 week. List thereafter for orders on admission. Admission not admitted as yet.
In final hearing.
All right. Let the appeal be listed for final hearing.
Please.
2012. First one injunction. IA 1 of 2012.
What is the injunction, Mr.? 1 of. Learned counsel for the appellant submits. Before that, you write. Submits that he does not intend to press IA 1 of 22. Accordingly, same
IA 1
is
of
dismissed.
12.
1 of 12. Same is dismissed as before.
DS Satin, KK Vasan.
Huh?
KK Vasan. Sir, you are muted, sir.
Tell him 2 weeks preemptory. We have granted him 2 weeks time preemptory.
Number 3.
Oh, 2 weeks time, failing which appropriate order shall be passed. You don't have to comply any of the objections. You don't have to comply any of the objections. All this thing by all this thing responded. You see whatever. Huh? See. Find whatever. If you have any default to the office objection, do it.
Number 3. Rajkumar,
2 weeks preemptory. After recalling also not mending ways, right? 2 weeks. 2 weeks preemptory. It is made clear that in case the appeal is dismissed for non-compliance of office objection, the application for restoration shall only be entertained subject to cost of rupees, payment of cost of rupees 25,000. You don't do it within 2 weeks. This is, I mean, height of indulgence, right? After being recalled again back to same old ways, then again for 1 year we will grant time. We don't know. Order has been passed. If you are agreed, Delhi.
2 weeks time is granted, Mr.
Number 5. We enter the
Appeal has been filed against judgment decree. And so the parties along with counsel present, learned counsel for the parties have filed a compromise petition, which has duly been signed by the parties as well as by their counsel. The terms and conditions of the compromise arrived at between the parties are as follows. What is it? Where are we? Paragraph 6A. 6A2. A to C. That's it. What? So, no. It has to be there, right? 14. No, 13.
4 wheeler. 4 2.
From 4 to
9.
4 to no. It's a recording of evidence. 5 undertakes to withdraw. 5, 5, 6. Paragraph
Up to
5,
9.
6, 7, 8, 9.
9.
9.
4 2.
The line below, the marriage between the parties is resolved in view of compromise arrived at between the parties. Marriage between the parties is dissolved by decree of divorce. The appeal is disposed of in terms of compromise arrived at. The appeal is disposed of in terms of compromise arrived at between the parties. After this thing, a sum of rupees 20 lakhs has been handed over by respondent to the appellant by way of a check dated 23/11/2022, the receipt of which the appellant has acknowledged.
From closing of the case, remind
It's all there. No, you did not tell us what are the terms and conditions. We have seen it. Yes.
perfect. In Amrita D. Health report.
3 weeks preemptory.
Yes.
3 weeks. 2 weeks.
7.
Review or service of notice on respondent is held to be sufficient as the respondent has refused to accept notice. Appeal is admitted for hearing record.
8. The adjective
2 weeks preemptory. That learned 8. Learned counsel for the appellant submits that the needful has been done. in view of proposed submission, office to proceed further.
The 9th, the correctional be
2 weeks preemptory. 2 weeks preempted.
10,
Party. Detail number 10 notice was issued for the party. While this is
None for the appellant despite notice being served on the appellant. It appears, mark his presence for respondent. It appears that the appellant is not interested in prosecuting the appeal. The same is therefore dismissed for want of prosecution.
number 11. Karnataka SP,
Weeks preemptory.
number 12, government advocate, 2 weeks.
Evidence. 2 weeks preemptory.
Kavita,
2 weeks preemptory.
Mohan K.
2 weeks preemptory. Order if any shall continue.
My lord, in this matter, my lord, for the appellant, I have already complained that order of the honorable court earlier on.
Yeah.
4. I shall file the acknowledgement before the court, my lord.
So when have you deposited?
7/4/2021, within 4 weeks granted by the honorable court.
Appellant submits that the amount of rupees 2 lakhs as directed to be deposited by an order dated 17/3/2021 has been deposited on
7/4/2021, 7th of April.
learned, however, learned counsel for the appellant undertakes to file acknowledgement within
Within a week, my lord, I shall file.
a week.
Much obliged.
Preparing for petition, my lord.
Huh?
Serial number 17.
You have served.
Yes, my lord. We are already IA 2 of 21 recall application, my lord.
Learned counsel for the petitioner submits that he has served the hand summons on respondent number 7 who has filed an acknowledgement 27 June 2022. Full stop. Let a copy of amended petition be supplied to learned counsel for respondent 4 and 6 within a week. Whatever. Respondents within a week.
Number 70,
Appearing for petition, my lord.
Ah.
What we already paying 1,000 rupees cost and IX.
Non-compliance. Recalling.
Recalling, yes, my lord.
What is non-compliance on IA 1 of 20?
My lord, last time we were applying for 21/91/22, IA 1 of 22.
No, you see.
My lord, we are paying also.
No, you tell us why cost should not be imposed on you. Cost of minimum 10,000.
10th, my lord,
Previous-
paying cost.
No. Tell us why it should not be imposed on you. Because earlier also 6 times you did not comply with office objections. And then it was dismissed. Again, you are just like that filing an application for recall. So
My lord, pending section is not given. My lord. My lord, pending section. Application complement.
of the divine, he has to come. You are not visible to us. Only the God behind you is visible. It's
My
good.
lord,
The
last time we
morning
were-
appearing through phone. Oh.
My lord,
Yes.
last time we are complaining the 19 and 21 complaint ಮಾಡಲಿಕ್ಕೆ ಫೈಲ್ ಕೊಡ್ಲಿಲ್ಲ my lord.
29/11, 6th time.
My lord, we are also paying 1,000 rupees cost, my lord. Please recall, my lord.
Recall.
We already
Ask you
complained.
deposit cost of rupees. Something. How much?
My
2,000
lord, we are
rupees.
already paying
Ah.
1,000 rupees cost. My lord.
1,000 rupees, 2,000, 2,000.
1,000 rupees already paid, my lord.
No, we don't. Subject to payment of the order, the record indicates that the appellant, after filing the appeal in the year 2021, had not complied with office objections for 6 times. Thereupon this court, just a minute. Thereupon this court, by an order dated 29/11/2021, directed, granted 2 weeks further time, and it was directed that in case objections are not complied with within 2 weeks, the petition shall stand dismissed. The appellant did not comply. The petitioner did not comply with office objections even for the 7th time. In the result, on account of peremptory order, the appeal was dismissed. Full stop. Thereafter, this application seeking a recall of the order dated 17/12/2021 is allowed. The after has been filed. After hearing learned counsel for the appellant and taking into account the conduct of the appellant in repeatedly not complying with office objections, the aforesaid interlocutory application is allowed, subject to payment of cost of rupees 2,000. In case the cost is paid within cost of amount of rupees 2,000 is paid in the account of High Court Legal Services Committee, order dated 29/11/2021 shall be, or Advocates Welfare Fund. Legal Services Committee. So and so the order dated 29/11/2021 is recalled. IA is allowed. Not filing statement. Assets and liabilities, right? Weeks time. 2 weeks time is granted to file. 2 weeks time is granted to file the statement of assets and liabilities to the respondent, failing which appropriate order shall be filed.
You also not
To the
filed.
parties. To the parties. Parties failing which appropriate order shall be passed. Office directed to be. Record petition is admitted for hearing. Learned SPP shall produce the record for perusal of this court on what date? 29th, 30th. 29th we are seeing. 29th November 2022. Is for hearing. You please make that matter. Mention this matter on that day after motion hearing. Don't wait for us. We do not. We don't. Know.
My lords, the notice has been served on 10th of November. Maybe 2 weeks time may be granted for receipt of the information.
Does not survive. Why? That's a different. What has happened? Why notice has been issued? Hey, just a minute. Short waiver. No, the petitioners had sought waiver of the requirement of deposit of 35 lakhs on the ground that after selling the property, the bank had a surplus fund of 1.1 crores. So then what is the fund in asking them to deposit? Now we will take it up. So our learned counsel for the petitioner submits that the notice has been served on,
10th of November.
served,
No, my lord, it's not served. It's sent through process.
dispatched on 10th of November 2022. Let service of notice be awaited. And list the petition as soon as the response. So,
Obliged.
31. Manjunath says,
production of appellant. On bail. What happened? Mr. Comment advocate. Huh? What?
In Bangalore,
Let it be day after. The day after, but tomorrow, learned additional government advocate prays for a short accommodation to enable her to seek instructions and to make a statement and to apprise this court with regard to status of execution of the non-bailable warrant against the appellant. List tomorrow. And if possible, you produce him. He is in Bangalore. See the order sheet, madam. First see.
sir, 22. Government advocate.
Await service. R5, R6. Why? 5 and 6. What happened to 5 and 6? What about 5?
I will receive the enhancement third copy because I will place it on Friday. It will be taken.
Yes, Mr. Ramesh. Learned counsel for the petitioner submits that he has served the hand summons to respond number 6. However, he prays for a short accommodation to enable him to serve hand summons on respond number 5. List on Friday, 25th November.
Lord, I appear for the NMC in this matter, my lord.
Acknowledgement.
Lord, I have, in fact, the learned counsel has served me a copy.
You appear.
Yes, my lord, they've served me a copy. My name may kindly be shown, and
Directed to take the name of Mr. So and so as counsel for respond number 1. In view of a aforesaid office objection is ignored. Yes.
my lord, may kindly have it on Monday. I'll have my instructions by then.
Monday.
Yes.
List. Mr. Ramesh, find out Friday or what? Monday. Friday. Friday, Mr. Khetti.
Let it be on Friday also, my lord. No problem.
Friday.
We'll try to
Yes.
expedite.
25th November.
Oblige.
No, it's not reserved. Yes.
24. Mufti Sharad.
Yes.
We complied with my lord.
Right. Learned counsel for the petitioner submits that office objections have been complied with. And then IA dispensation heard on IA 1 of 2020. Requirement of filing certified copy of annexures is dispensed with. In result, IA 1 of 22 is allowed. With- Have you supplied a copy to Mr. Ramesh? No. So we will have to grant them time. Tomorrow we will take up. Now, whatever. Mention at 10:30. What would Mr. Mark, let a copy of petition be supplied. You have got Mr. Lakshmi Narayan. Mr. Lakshmi Narayan, Learning Council appears for, Government Advocate appears for 1 and 4. Let a copy of a writ petition be supplied to Mr. N.K. Ramesh as well as Mr. Kheti, N.K. Kheti. Office is directed to reflect their name. List tomorrow.
He was here.
Issue notice of IA 1 of 22, 2 of 22, 3 of 22. Proposed LRs of disease, respond number 4.
26. With Praveen Gowda.
Filing application. Also,
Appear for the Lord in this case, respondent, my Lord. My Lord, I request, my Lord, one more opportunity to, my Lord, file the objection to the IA, my Lord, applications.
what
Delay
file?
because there is almost, my Lord, 14 years delay in the, my Lord, filing the appeal. Time is granted, my Lord, at least 1 week, my.
So you also want to file a delayed response, right? Is it
Yes, sorry.
14 years time to file objections?
No, appeal has been filed, my Lord, after 14 years. No. Sorry, my Lord. At least weeks time. Sorry.
Learned counsel for respondent praise fund is granted. How much time? 10 days.
No, yes, my Lord. That's
10 days time to enable him to file objections to IA 1 of 2019. This
Obliged.
there are.
obliged.
28.
Hearing? What? What do you do? How many dependents on him? Is there any child from the, no child? So his parents are there. How much has been given? 3 lakhs. How 6 lakhs? What? That's the only thing, Mr. Why shouldn't you? He should buy peace instead of, I mean, he is not agreeing with this. Huh? But you are required to take care of your wife also. What? How much do you want, Mr.? What's? Yes, Mr. How much? 7 lakhs, 6 lakhs has been awarded. 20. No. We are talking about permanent alimony, right? Huh? Yes, this is not a criminal case, right? Even if allegations taken at the face value, then also no case is made out Therefore, complaint should be quashed. That is the law in that case, 482. No. Go. Mr. No, 7 lakhs by 6 lakhs by any standard is on the lower side. Huh? Working in? Acha.
Is the appellant doing?
What do you do? Don't do anything. 10 lakhs. Thanks. You are satisfied with 6 lakhs, right? You have not filed an appeal.
Because
What site? You have not.
Did you
made-
make a claim for alimony? Where? Where is that? If you have filed an application under section 25, where is the discussion about your, either in your main petition or in the, you should have filed as a application. Where is that? Where is that? In the main petition, where is the prayer for alimony? You have never made a claim for alimony at all. In spite of that, the court has granted you.
That. Site will decree 7 lakhs and granting liberty to file a petition. You can file a petition under section 25. Lead evidence, whatever do. No, but what about this proposal, Mr.
Where is it? Nominally,
8 lakhs.
8 lakh.
Yes. So, not entitled to maintenance. Yeah. You have remarried.
have to buy that property.
Her father has gifted it, right? Have you purchased? Have you purchased? Us?
36 minus amount is factor. I was the appellant. Use the passbook and bank. Yes, sir.
What is the post he is holding in that chess form? What post?
I can.
What assistant? Assistant officer. Where is? It's on record, right? His salary certificate. It has been reduced salary. 2019, your salary has been reduced. They see that this is this. This is also your salary certificate. Okay. 36,274. 36,274. Huh?
40,000. Around 40,000 at present.
So what? What's your salary must be around 40,000 now. Statement. 8 lakhs.
8 or 9 lakhs.
That's it. Anything else? And you are in such a hurry that you got married, right? Yes. Hey, this Mr. Nataraj. 3,000. You are having an agricultural income of 10 lakhs. How many land? How much? How much? How much? Where is the finding with regard to alimony? Para? These are not in his name, right? So So decree of divorce has been granted on the ground of duality.
Yes, not contested at all.
Oh, not contested. You are always interested in second marriage, so therefore did not contest. Huh? What can be done then? Nothing. Yes. This appeal under section 19 within bracket with heard on IA, etc. allowed order sheet, arguments heard, judgment dictated, signed, dated, separations. This intra-court, this appeal under section 19 within bracket 1 of the Family Courts Act has been filed against judgment dated 5th of April 2019, passed by the Family Court by insofar as it this intra-court appeal so and so has been filed against so and so, passed by Family Court, seeking enhancement of amount of permanent alimony. Paragraph. Facts giving rise to filing of this appeal briefly stated are that admittedly the marriage between the parties was performed on 28/11/2013. Full stop. The respondent, the appellant, filed a petition on 24/6/2015 seeking dissolution of marriage on the ground of cruelty. Full stop. The respondent did not contest the proceeding. Full stop. The petition filed by the appellant was allowed by judgment and decree dated 5/4/2019, and the marriage between the parties was dissolved by a decree of divorce. Full stop. In addition, the Family Court, by taking into account the fact that the respondent is employed in which company? Chess. Chamundeshwari Electricity Supply Company, directed and the joint family of the respondent owns agricultural land to 3 acres and 24 guntas, granted permanent alimony of ₹6 lakhs. Full stop. The appellant wife has filed this appeal seeking enhancement of the amount of permanent alimony. Paragraph. Learned counsel for the appellant submitted that the salary of the respondent in the year 2018 was ₹33,000. 33,080 rupees, which must have been enhanced by now. It is further submitted that joint family of the respondent owns agricultural land measuring 3 acres and how many guntas? 24 guntas. Full stop. It is further submitted that the amount of ₹6 lakhs by way of permanent alimony which has been awarded to the appellant is deserves to be suitably enhanced, taking into account the resources of the respondent. On the other hand, learned counsel for respondent has submitted that respondent has remarried after the judgment and decree, and therefore it is also urged that the amount of permanent alimony granted to the appellant is just and proper and does not call for any enhancement. Paragraph. We have considered the submissions made on both sides and have perused the report. From perusal of this was an exhibit, right? Salary from perusal of exhibit. Mr. From perusal of exhibit P14 to P16, namely the RTC extracts, it is evident that joint family of the respondent owns agricultural land measuring 3 acres and 34 guntas. 24 guntas. Full stop. In addition, the salary certificate exhibit P17 indicates that the salary of the respondent in the year 2018 was ₹33,080. Full stop. Undoubtedly, the respondent is under a statutory obligation to maintain the appellant maintain the appellant. Full stop. The
6 lakh is not deposited.
execute
That is lying, 6 lakh is lying with him.
6 lakhs is with you.
It's not deposited.
But
You have not paid the 6 lakhs till date.
it is convenient. That's very convenient, right, to you. 3,000. Yes. No subsequent. You have this thing landed yourself in trouble. We cannot help it. Taking into account the salary of the respondent as well as the agricultural income which his joint family derives from the agricultural land, we are inclined to enhance the amount of rupees 6 lakhs granted by way of permanent alimony to rupees 8 lakhs. Full stop. Paragraph, the judgment and decree dated 5th of April 2019 is modified to the extent mentioned above. In the result, appeal is partly allowed.
Next.
The appellant enhanced to 8 lakhs. The respondent shall deposit the amount, aforesaid amount, within a period of 4 months. 4 months from today. 4 months today, failing which
You have granted 4 months.
4 months time, failing which the appellant shall be at liberty to seek the execution of the decree. Modified this thing. You said no, that you will give it. He said in lieu of. File a suit. No, this is maintenance, Mr. We can't decide the question of title in a property in this appeal. Summary nature, incidental question. File it's Benami, your father's property, whatever. To file a suit against.
Yes, we continue and the rest of our life.
It depends on his status, right? You cannot live like a daughter-in-law of Ambani's family, right? You cannot live a life like daughter-in-law of some big businessman, right? You are a wife of an employee of Chesscom, whatever. You will be entitled to that. What can? Yes.
By 29, Basura Pratik के
Passport.
for admission.
Admitted for hearing. Record. What about maintenance? Yes, madam. 30.1. What is your husband doing? Assistant professor in RV. What's your salary? 1,90,000. So, like how much trial court had family court has awarded? Huh? What then you?
I got the maintenance awarded by the child court. And
So what are you? You are an engineer.
the IBM.
So what's your salary?
So I assets and liabilities, I'm doing salary of 9 lakhs.
Lakhs. So what would be like monthly? 9 lakhs per. Wait. $75,000. All right. So yes, but you are earning 75. The argument is that you are able to maintain yourself. Two children. Oh. Huh?
My parents, I'm also taking care of them.
Just a minute. 1 minute. Later. Yes. So 2 children. What is the age? Their age?
Children.
12 years. Studying. Study. Yes, Mr.
Ready to come out because she had to maintain her parents. So she left that particular our practice before. And we gave to the employer and we have requested her to hand over the child to us. That was also done. And they have not readily and they have not
Here. Also, you should be thankful that she didn't fight. So it will be awarded only from the date of application.
Right.
He is employed. But only for children.
You cannot get away with this. You have to maintain your children, right? This is which law says that in case you are required to pay maintenance, you can demand custody in a reply to an application under section 24. Which law? Is that she may not need, but children need maintenance, right? Who will look after them?
I will
On
Wait, madam. That she should be directed to pay maintenance to you. That is the humble submission. So there is an act for which you are required to initiate a proceeding and seek custody or visiting right. This can it be done in a, you can make an application here also. Right. Yes. Call for records. Heard. But we are passing an order. You can show admission at the time of hearing of the appeal. So appeal is yes. 30.1 matter. Yes, right. Heard on IA 1 of 2019 and application seeking maintenance. Learned counsel for the appellant submits that the marriage between the parties was performed on which date, madam? 22/2/2007, and the parties have twin children. Twin children from the marriage. It is further they are sons or daughters? Acha, it is further submitted that daughters are aged about 12 years and are the appellant is and appellant is in custody of the daughters. It is further submitted that appellant is required to incur considerable expenditure on the upbringing of the children. It is also submitted that appellant is employed as an engineer in IBM and is drawing a salary of rupees 75,000 per month. On the other hand, learned counsel for respondent has submitted that the respondent is employed as assistant associate professor in RV College of Engineering and draws the salary of rupees 1,09,000. It is further submitted that that in case the appellant hands over the custody of the children to the respondent, he is ready to maintain them. Paragraph. We have considered the submission made by learned counsel for the parties. Admittedly, the appellant is gainfully employed and is drawing a salary of rupees 75,000 per month. However, the fact remains that the appellant is taking care of the twin children born out of the marriage, born out of the wedlock, and is required to expend considerable amount towards their upbringing, including their education. The respondent is under a legal obligation to maintain his daughters, full stop. Paragraph taking into account the salary of the respondent, it is directed that respondent shall pay a sum of rupees 40,000 by way of maintenance to the appellant, 40,000 by way of maintenance to the children, which shall be payable to the children, which on account of maintenance and education of the children. The aforesaid amount shall be transmitted by the respondent every month by RTGS in the account of the appellant. The aforesaid amount shall be payable to the appellant from the date of application. Accordingly, IA 1 of 2019 is allowed. Record. Yes, thank you. Yes.
31.
We should have granted. No, so how much? You so long as you detain us, it will be enhanced. It should be enhanced to 50,000 now. What? Humble submission before Honorable the Supreme Court. Right? Yes. So, what is it? Admitted for hearing. Record. Huh? Place for adjournment on the ground that the arguing counsel is unwell. Made clear that no further adjournment shall be granted. You have 2 weeks. 2 weeks time. Made clear that no further adjournment shall.
33.
I appear for the respondent, my
Admitted
lord.
for hearing. Record.
34. Yes, Sarati. Government certificate. Kumar.
Huh? Huh? We'll admit it. Appeal is admitted for hearing. What, there is a direction to produce the record. So you keep it, learned additional government advocate shall keep the record of the proceeding in a sealed cover and shall produce it and shall produce the sealed cover on the date of hearing. We'll do it, of course, when it is heard. Produce it. In pleading appeal shall be heard. And this then shall be taken up at the time of hearing. Interim order, if any, shall continue.
Date will be fixed not the hearing.
File an application. This is not that court is admitting automatically a corresponding right accrues to you to this thing or seek an early hearing. This is 21 appeal, Mr. What file show urgency? What is it? We will take up. Not like this. Why 2009 appeal should not be taken up? 2009 appeal, you people seek adjournment, and 21 you want a hearing because client is sitting. He's pestering you for an order, right? So that's why. Who will argue? First argue a 2009 appeal, don't seek an adjournment, ask the members of the bar not to seek adjournment in 2012 matters. Then we will hear 21.
If I, the DB party.
Yes. What? Who senior? Huh? What is there? Nothing in your case. There's nothing in your case. Right? Notification under 28.1 and 28.4 have been quashed because despite publication notification under 28.4, for 10 years you haven't taken an action to conclude the proceeding. So this is it. Yes, right of learned single judge by an order dated 24/11/2020. 24/11/2020 has quashed the notification issued under section 28.1 and 28.4 of the KIADB Act on the ground that despite issuance of notification under section 28 within bracket 4 of the Act for a period of 10 long years, no action was taken by the board to conclude the proceeding. However, learned counsel for the appellant pays for accommodation on the ground that the arguing counsel is unwell. List next week. Petition is admitted for hearing, issue notice record. Next.
Manos, I'm appearing for the appellant in 37. We have filed the objections on 21/9/21 and we were supposed to argue the appeal. I am ready, Manos. I just wanted to bring to Manos notice one thing, that during the pendency, Manos had specifically said on 31st May 2022 that the status quo would remain. Manos, they have proceeded to have a committee, and now the committee is taking over the management of the Baba Budan Dargah, which is completely in the teeth of Manos, the spirit of Manos order, Manos. And in fact, Malos was very kind enough to allow them to proceed with the inquiry. We also did not object to that. We said, all right, have an inquiry, file the report. The report was filed. We have filed objections. Now, when the matter is seized by Malos to proceed with appointing a committee and taking over the management is completely, Malos, I'm so sorry, Malos, but it's completely unfair. So, my lords, I would appear, I would conduct the matter also if my lords deems it fit, or my lords in the meantime, stay that management committee, my lords, please.
Yes, yes, yes. Tell a date. Tell us. Yes, madam, which day? We will hear it.
Any date per my lord's convenience, but in the meantime, please let not the management committee take over the administration.
Monday,
Very well, my
Monday.
lords. Very well, my lords.
28th November.
Very well, my lords.
Huh? Oh, so you will have to. So learned advocate general will make a request to you to improve your network so that he can hear you.
My lords, then would my lords consider having it, my lords, on Wednesday, so I can come physically and appear, my lords.
Yes.
So that would be.
Monday is fine.
So she says Wednesday, 30th.
Or at whatever is convenient to the learned advocate general, I have no difficulty.
30th, fine. All right.
I'm grateful, my lords.
Learned counsel for the parties jointly submit that they are ready to address the final arguments in the case. Paragraph taking into account the nature of controversy. Let the appeal be listed for hearing on 30th November 2020.
I'm much grateful, my lords, and also to the learned advocate general for accommodating me.
Slow motion. Oh, so now she will be here. You will have the benefit.
This particular. Under the law, how do
What happened to the this things? Interconnected read petition.
Circular cannot be the law. It has to be development charge. It cannot be.
No. Learned single judges followed the decision, right? Coordinate bench. We are asking what happened to that. If it is appeal has been dismissed, then what happened? Find out. No?
Base of the circular is under the code and 466 and 467.
Article 65 and 338. Just because they are statutory bodies, they cannot.
Found out whether they may believe.
Yes, Mr. Can you find out any appeal? That's all right. We decide. Yes, RB. What? Yes.
Section 466 and 4. It does not give the. Purchase of the property he made. Of time, Section A was issued calling upon the petitioner to pay their determined charge, which is not permissible under the law. This honorable court, they are not. Thereafter, he made an application for sanction of the law. Both betterment charges as well as the government charges. circumstances, I have filed a writ petition before this honorable court for refund of both the betterment charges and development charges, as it is not permissible under the Karnataka Municipal Corporation Act 1950. The property is
Yes. Which act?
1976 Act.
Okay, Mr. Municipal Corporation Act. Read it.
Power to declare expenses on capital work and improvement charges. If the expenses to be recovered from have been incurred or are incurred in respect of any work mentioned in section 189, 25, 27, 72, 83, 328, 332, 337, and 376 or 462. In any rule made under the Act in which this section is made applicable to such expenses, the Commissioner may, if he thinks fit, and with the approval of the Standing Committee, declare such expenses to be improvement expenses. Three conditions on your first, expenses have to be incurred. Thereafter, in the Standing Committee, it has to be approved. Then it has to be collected from the person in that particular locality where such improvement has been taken place. That is the precondition for section 466. 467. Improvement expenses by whom payable. Improvement expenses shall be a charge on the premises, in respect of which or for the benefit of which the same shall have been incurred and shall be recovered in the amount and at such interval as such expenses determined. The said installment shall be payable by the owner or occupier of the premises on which the expenses are.
We should see this.
Okay.
Yes.
Condition.
Next. 69. Hey, Mr. What happened to this order? The passed in WP 56465.
565.
56465 and 56724-734 of 2014. Any writ appeal preferred, we can find out. Writ appeal preferred, what happened? This order dated is 26/8/2016. Mr. Nataraj. Order is dated 26/8/2016.
Provisions are very clear. If the charges are development charges or betterment charges. What included expenses which has been mentioned in 466 and 467, they are totally different from what has been demanded from the petitioner. Annexure A is the improvement charges which has been demanded. Is a case number 22 is the original copy in Kannada, 23 is the copy in English translation. Item number 4 in that particular page number 23 English translation, payment of property betterment charges of 42,300. Which Corporation Act 1976 is about betterment charge. And in that endorsement, nowhere it is stated under what provision of law this particular amount is being demanded. A citizen has a right to know under what provision of law the amount is being demanded. Otherwise, it's fundamental right of 300 capital A of the Constitution of India. Because without there being any statutory liability on his part, it's not about to pay some amount. Merely because the person who is demanding such money is a statutory body in the absence of any law. Your Lordship, page number 32 and 33. Your 32 is Kannada version, 33 Your Lordship, page number. Going Raj Nagar 4,03,733. What right they have to collect once again and for what and how has been arrived at, what is the procedure, what are the how it has to be calculated. Tax does not mean that they can demand any amount and citizen has to pay the same without knowing what is its nature, how it has been written. That is not the law. Tax laws are well settled.
Thank you. We did not know this. Thank you for enhancing our, we did not know that tax law is not like that. Yes,
These are the facts.
that's it.
So I am entitled for the refund of this particular amount because they have been collected of law. Any tax which is collected without authority of law has to be refunded with interest beyond. Direct decision is HMM Limited. The citation, population has been filed on 15th September 2020.
If you would be kind enough only to tell the paragraph, this, if tax is illegally collected, it has to be refunded. This much of law, you should trust that we know. That's why we are here, right? Something we know, right? My brother has been a judge for 3 years. I've been a judge for 13 years. We know something. We learn from you every day. So you believe, you can rely that Mr. Ashok Haranalli must have told us that if a tax is illegally collected, it has to be refunded. Which paragraph? You don't need an authority for this proposition, but thank you for citing it and tell us which paragraph.
Yes, sir. In respect of first citation, there are number 39 41.3, 4 and 5.
39.
39.2
2.
and 41.3, 4 and 5. Thank you, Your Worship. In respect to HMM Limited 1989 4 SCC 640, para 12, page number 40, Your Worship, in comparison, and para 12 is at page number 49.
Your choice, Mister. Your choice. I mean, we are bound to hear you and.
These observations in our opinion, in view of the contentions raised on behalf of the losing party, here are appropriate in this case. The amount have been realized as occupied on the entry of the occupied.
Yes.
Which occurred during the period of here, illegal entry into the city limit would not attract the levy of fine unless we are brought in by use or confusion of it. In this case, the order returns to the order.
Hey, Mister, this is not a case of an entry tax. Please don't read it. When you are relying on one judgment is sufficient or not. Mr. One judgment, Mr. Jain, one judgment also binds us under Article 141. There's no point in multiplying the authority for the same. Vatika Township must have been cited n number of times before us. I have sat in that bench for 2 years. Be considerate, Mr. Others are waiting. There's no point in arguing that flogging the dead horse. You have told us that if there is illegally this thing collected, there's nobody is disputing that you are entitled to refund. Who did we say that you are not entitled? Then why judgment after judgment? Same proposition. We have other things to do also apart from your case. Thank you. We'll pass an order. Next.
File number is changed, sir. File number is 132. Get the file.
Get the file. Next. Next. Yes. Take this file, not just this one.
Yes. Take.
Having regard to the section 16 of the Arbitration Act, another single judge has passed an order to the effect that even the jurisdiction of the arbitrator can be challenged before the arbitrator. That is some circumstance of order.
Yes.
Order but then and it is permitted by a little synopsis.
Yes. Yes. Yes.
Well, it's like 5 lakh. This RCC papers were ordered to be birthday and the railway department is the line paper. Therefore, the contract between the railway department. For the purpose of supplier, 5 lakh RCC sleeper for the track which will be ETB. And there were variants of the rate regarding the supply of the high tension wire which is being used in the particular railway track. I mean, that particular sleepers. Matters were negotiated second time also. The parties have supplied it. Then small dispute arose between the parties. They have approached this honorable court. The matter was, which is the important from my point of view, was referred to the after passing of the arbitrator has passed the award. I think create is a response. In the sense that some amount to me, but adjusting that all that amount was paid to the contract. In that regard, my lord, straight away I pray, my lord, in the synopsis, my lord may kindly term 2. 24 or 21? Page number. Clear. The part of the work record also comes.
27.
If the target goal line, if pursuance of the letter dated once, Chief Engineer on behalf of the engineers one. Condition number, claims certificate dated 16th being rejected by the office of one. We are here with submitting certified. We have no claim on the issue in that. We are willing to accept, check, prepare and get ready by the relevant for the full and the final settlement of the award. This was the final settlement which the contractor has given to us. After the arbitration, after passing of this, after settlement of this, we have chosen to prefer a petition and for the matter. That's on page number 28. And the sum and substance of that allows before into the future. For the it's not interfere with the award. So observation. That the petition can have been to be carried out by the industry. But in view of this, the motorcycle, the hearing the party, the appellant wanted to withdraw the pitch. So thereby, the observation that's now 3 lines observations, whatever no I have made read to me, that has to be reviewed. That's still page number 35, 36. Paragraph number 6, Mala. So it's one of the letter to so and so on record for. Therefore, we pass the following order. Interstate Court Appeals number so and so stands withdraw. Second line on para number 7. Stands withdraw. Well, as far having after withdrawing, that is the submission. But however, the division bench further observed that you can go bit. Incidentally, in the 26th 2017, Once that act has been used, the matter just get to the the MSND refers the matter to the arbitration council of Karnataka. The Karnataka arbitration council honorable judge as the arbitrator of this dispute. My only question, otherwise, I am before this arbitration. Number one. Arbitration remain in that. Under such circumstances, it is my submission that the question of moving by MSME to the once again before the arbitrator under 96 Act does not arise. That is the first submission. The second submission would be whether the whole matter could be reopened. Well, only one or two seconds. How many days, my lord, we are fighting, both of us were playing in lakhs, 50 lakhs, 20 lakhs, 30 lakhs. In view of this multiplication of the interest act, now for rupees 25 lakhs, the claim is to the extent of 1,300 crores against. Well, this is no doubt, my lord, the figures will not change the question of law, but only it is that is also another equity, my lord, which I am before this honorable court. My only submission at this juncture would be arbitrator not be having this. But one fact I should also straight away submit before the other should. Jurisdiction is concerned. We were unable to take up the matter well within the time. We'll have the matter was argued before the honorable learned arbitrator. Arbitrator has also taken the view that he has got it. I mean, I should submit, my lord, that view he has taken it against me. This is how, my lord, I am placed. Therefore, my lord, I am seeking this requires a consideration matter. My lord, only one thing. The 93 Act, it was amended in the year 1998. While amending section 7, it is available on page number 11 of the papers, my lord, the synopsis. Well, 7A, insertion of a new section 7 ABC. And the council has been, my only submission before my lord would be, before 1998 and the section 6, my lord, they are required to go to the everybody. This subsequent amendment is of 97. All the transactions, contracts, everything, it is again. Therefore, this may not be applicable.
Decided. Yes. No, no, so this, Mr. In pursuance of the order passed by the learned single judge, they have raised an objection. They had raised an objection about the jurisdiction of the arbitrator. And the arbitrator, what he admitted that it has been decided against them, by which order arbitrator has already held. No, no, no. The learned single judge has permitted them to raise an objection. So by an order. By what order? That's what we are asking. So their sole contention is that the proceeding, the arbitrator has no jurisdiction, right? Section 16. Yes. This is the order which is passed. Yes. Yes. That's it. Oh. Yes, thank you.
Evidence or anything. Only one prayer I can make in the event. But let me assume the other way. I'll be losing my claim. In the event I'm losing my claim. Various sentences we have got it in this case. All those sentences may kindly be delivered to us. That is the only 1,300 crores. That is the only. It's a classic work. I say. How government works? It's not that it is a public money. Sometimes the government also there will be some. Accounts are there within the establishment. Public. No claim certificate.
Yes. Petition conciliation.
More effective. More effective.
it up. Decide here itself why to keep it the way. We don't have time. We are busy in lunch. So, yes, madam, right. This intra-court appeal. This intra-court appeal is filed against an order dated 2nd of February 2022, passed by learned single judge, by which a writ petition preferred by the appellant has been dismissed. Dismissed paragraph acts giving rise to filing of this appeal briefly stated up that the respondent number 2 had initiated a respondent number 2 that micro, small, and medium enterprises Facilitation Council. Facilitation Council by an order dated 23/12/2019 initiated the proceeding under the Micro, Small and Medium Enterprises Development Act 2006. Full stop. It is the case of full stop. According to the appellant, the council had no jurisdiction to initiate the proceeding. Full stop. The appellant therefore challenged the aforesaid order. Something else.
23/12/2019 is a letter.
What is this order? 20th March 20. That's the order under challenge.
Appointing the arbitrator.
20th March 20.
$72, sir. 372.
70.
Communicate.
So the appellant was informed, right?
The second respondent issued a letter dated 23/12/2019 to the arbitration center at Bangalore. That since the conciliator cannot be appointed as an arbitrator, appointed arbitrator from the panel of arbitrators.
All right. So he not initiated the proceeding. Delete this. So and so phenomenon not holding the this intra-court appeal filed against dismissed, then so and so facts giving rise to filing of this appeal briefly stated are that. Where is that? Page
70, that letter.
That so and so council, right? Whatever you have written, small so and so, sent a communication dated 23/12/2019 by which Arbitration and Conciliation Center, Bangalore, was informed that under section 80, informed that conciliator cannot act as an arbitrator, and therefore the Arbitration and Conciliation Center was directed to nominate, to appoint an arbitrator to conduct the arbitration proceedings under this Micro, Small and Medium Enterprises Development Act 2006. Full stop. Thereafter, full stop. Thereafter, by an order dated 20th March 2020, comma, the appellant was informed, right? Yes. The appellant was informed that the proceeding are fixed for 23rd of March 2020 to nominate for nomination of arbitrators from both the sides. Full stop. Both the sides. Full stop. The appellant, paragraph. The appellant challenged the validity of the order dated communication dated 20th March 2022 in a writ petition inter alia on the ground that the arbitrators have no jurisdiction to arbitrate the dispute. Full stop. The learned single judge by impugned order has dismissed the writ petition. In the aforesaid factual background, this appeal has been filed. Paragraph. Learned ACI. ACI. Paragraph. Learned ACI submitted that learned ACI submitted that the learned single judge have learned single judge ought to have appreciated that the earlier order in the previous arbitration proceeding stand and the arbitrator has no jurisdiction to entertain the dispute. Full stop. On the other hand, learned senior counsel for respondent has submitted that in pursuance of the liberty granted to the appellant, the appellant had raised an objection. Had raised an objection which has already been adjudicated by the arbitrator by an order dated 23/6/2022. Paragraph 23/6/2020. And the appellant is at liberty to take recourse to the remedy prescribed to him in law. Full stop. Paragraph. We have considered the submission made on both sides and have perused the record. Full stop. Under Section 16 of the Arbitration and Conciliation Act 1996, an arbitral tribunal is competent to rule on its own jurisdiction. Full stop. In case arbitral tribunal has the so and so jurisdiction to rule so and so. Full stop. Full stop. The learned single judge, therefore, has granted the liberty to the appellant to raise the objection with regard to jurisdiction of the arbitrator before the arbitrator itself. It is also pertinent to note that in pursuance of the aforesaid liberty granted to the appellant, the arbitrator has adjudicated the objection preferred by the appellant with regard to his jurisdiction, and by an order dated 23/6/2022 has held that the tribunal has jurisdiction to deal with the dispute. The appellant can take recourse to such a remedy as may be available to him against the aforesaid order dated 23/6/2022 passed by the arbitral tribunal. Paragraph. Arbitrator. Passed by arbitrator. Passed by the arbitrator. Full stop. Paragraph. For the aforementioned reasons, we do not find any ground to interfere with the order passed by the learned single judge. However, all contentions are kept to all contentions are kept open to be agitated in appropriate proceeding. Accordingly, with the aforesaid liberty, the appeal is hey, you are getting so many cases on interestment only, keeping Mr. Arbatti busy, right? He should notice. He should. Mr. What? Covered. Hey, what, Mr. This we have taken a view, right? It's maybe wrong. We are bound by our own view. So you should say that it's covered. Don't. Then. All right, stay is operating, right? You be happy, Mr. Appeal is admitted for repetition is. What difference? Then you should be Mr. Fair enough to say it's covered, right? It not to your liking, but it's covered. It's covered, no judgment. They yesterday only we delivered a judgment. Factually correct statement, you should be able to make that it's correct. But you are then still trying to distinguish it by saying that it is that small distinction. What distinction? Covered or not? Covered. Obviously, petitioner. What? He is not concerned with others. What is it? Judgment? What? All right, yes. Right now. Petition is admitted for hearing with consent of the parties. The same is heard finally. Yesterday, the petitioner is a retired employee of Karnataka Rural Infrastructure Development Limited. Full stop. In the instant rate petition, the petitioner inter alia has assailed the validity of the order dated 27/7/2022, by which the inquiry has been entrusted to Lokayukt to initiate disciplinary proceeding against the petitioner. Paragraph. We have heard learned counsel for the parties at length. The issue involved in this writ petition is squarely covered.
50413
Squarely covered by a judgment dated
22/11/2022. Passed in writ petition number 50413.
Ah.
3/19.
Where is that order, Mr.? Yesterday.
Yesterday pronounced.
Not reserved.
Yesterday it was pronounced. Yesterday.
I know that. Where is that? Fairly covered by judgment dated so and so, passed in WA number so and so. Full stop. Paragraph for the reasons assigned in the aforesaid judgment, impugned order dated 27/7/2022 insofar as it pertains to the petitioner is hereby quashed. 27/7/22 as well as the report dated 24/1/2022 submitted and no report will stay. The order dated 27/7/2020. Mr. Get it. 27/7/22 is hereby quashed. And the liberty. Get it? Not approved. After 1 month, it will be approved. Huh? You see.
What also has to go?
Maybe don't. In terms of that order which has been delivered, yes. Give it, please. Get a last page printout, that's it. It will just now tell you. With the liberty what? Yes. Yes, that's what. That's why we are waiting for that. Last page, Mr. Yes. So one sentence only. So there has to be, you should have said that the benefit of the order be confined to the petitioners only. That's it. End of the matter. No more submission. Cost of ₹1 lakh. If you make any submission. No, if you make any submission, we will impose cost. Payable to Mr. Arbatti. He has been contesting. No, Mr. On technicalities, you are succeeding. What have you done? You have done an act of bravery, for which you are being rewarded. Why inquiry has been held against? On technical grounds, Mr. Technical grounds. We don't want to say, why do you invite comments about your conduct of your client? He is succeeding on technical grounds. Why should you invite comments? You have not done an act of bravery, saved 10 lives, for which you are being punished. Mr. Lakshmi Narayan is holding an inquiry against you for saving 10 lives of the citizens. Is it so?
Yes, but this is for non-profit.
You can dictate if you like.
Yes. Number 42, even J.
Sir, Nataraj, last page.
Yes, and personally.
Personally?
Personally, yes.
Go. He has to go personally or what? He cannot send anyone. Yes.
The previous University Act 2012.
You have challenged the validity. Right?
No, madam, the 350.
They have promulgated so as to enable you to challenge it, right? If they would not have promulgated, no writ petition. And no Mr. Shetty. Yes, heard of the question of admission. Issue notice. Notice on behalf of respondent number 1, accepted by Mr. Lakshmi Narayan. Issue notice to respond number 2. Yeah, how much time? 4 weeks. How much time? Objections. See,
Regulate committee, another examination of.
you should notice to R2 and he are asking how much time do you want to file of this? Learn it and government advocate Pressman is granted 4 weeks time.
Respondent number 2, N. K. Ramesh is appearing.
4 weeks time to enable him to file objection.
No, so Mr. Omkar,
Pay process fee, right? In addition, if
please, in addition.
in addition. Why this is this thing virus? Let the notice go. What's the yes?
By the fee fixation committee constituted by the government. Once again, the fee fixation committee.
We consider after. Let them respond then. Yes.
Yeah, observe that.
What?
The reason is the fee committee is proceeding further. That's the only reason. Then entry model will be considered after.
Prayer for interim relief shall be considered after the respondent files objection. Right. Yes. That IA, etc. You allow both IAs, 1 of 22, 2 of 20. Dispensation. Supply a copy. We don't have any means of finding out ex party. Supply a copy to Mr. Ramesh. Mr. Shrikant, learned counsel, undertakes to supply. No, Mr. Lakshmi Narayan accepts respondent number 2 and that's all. No, let a copy of petition be supplied to Mr. N.K. Ramesh. Office is directed to reflect his name as counsel for respondent number 1. Then on behalf of 2, he accepts notice list on Friday. There are urgency, right? 25th November. We don't know. Hey, you should have keep this argument ready for 25th, not now. 44. Dispensation. One. So government order dated so and so. And insofar as it pertains to the that whatever order dated so and so previous is insofar as it pertains to the petitioner is hereby quashed. The board, however, is granted the liberty to consider the report submitted by Lokayukt under section 12(3) of the Act and to take an appropriate decision in accordance with law within a period of 3 months from the date of receipt of certified copy of the order passed today. Line below, accordingly, petition is disposed of, right? You have written, no? Quashed insofar as it pertains to the petitioner. IA for dispensation, right? Heard on IA 1 of 2022, the requirement of 44, the requirement of production of certified copy of the annexures is dispensed with. Later, notice on behalf of respondent number 1 is accepted by learned government advocate. Let a copy of petition along with annexures be supplied to Mr. N.K. Ramesh. Office is directed during the course of the day. Office is directed to reflect his name as counsel for respondent number 2. You tell him, Mr. You supply a copy list on 25th November. We will hold a special round of counseling for you if it's so meritorious. Don't worry, you should have, madam, you should have supplied a copy of this petition in advance to Mr. N.K. Ramesh. You know that this is all lack of experience. What can we tell? You should have requested him to remain present. We could have asked him to seek instructions. What can be done? We will not grant you in a blanket sort of an ex parte interim order that he should be permitted and should be awarded a gold medal. You can't do like this. We will have to find out why you are not being permitted. We have kept it. Tell him, Mr. Ramesh, that he should seek instructions, provided she supplies a copy today. Otherwise, 25th also it will be adjourned if you don't supply. Last over matter. None. None for the appellant, even when the matter is called in second round. It appears that the appellant is not interested in prosecuting IA 1 of 20 and 1 of 2019. Accordingly, same are dismissed for want of prosecution. Yes, 29. Not there. none for appellant even when matter is called in second round. It appears not interested, dismissed for want of prosecution. Right. Array, Mr. Ramesh, there were two cases, right? You have to seek instructions. Huh? It's coming up day after. One is that he is not being, Mr. Lakshmi Narayan will tell you. 30 lakhs. Yeah, 3 months. None. Only listed. Oh. Huh? So they have already, they are submitting an explanation in advance. Huh? Yeah, these people, they are totally non-serious. They are road branch people. They are educated.
His number is 1221, file sent is 1222.
Acha, let this appeal be listed in the next week. Whatever record.
The tender was by entity not by Department of Directorate of Employment and Training. 2013. Certain, I pointed out certain lapses and not the tender was retained. It was retained. Price not that every time. Point out some illegal. The retendering. Finally, not the department despite the illegal.
He means, who are you?
I mean, not
A public spirited individual. You are a public spirited individual. Oh.
I am not one of the parties.
Acha, party.
Who participated. And also the on the open.
Oh.
I not pointed out the illegality. They admit that and re-tender it for 3 times. Finally, not on 24/5 with the same party issues, not they go ahead and award the tender to this very entity, which is not the rest. Now, what happens not? I have filed a formal complaint, and against the formal complaint, kindly see the scrutiny, initial scrutiny note that is 107. Where not the notice. Must lapse. This is not the entity which is awarded the tender. Lordship may kindly see your observations. So and so is the manufacturer. The technical evaluation committee has treated the said firm as authorized dealer, and therefore firm was technically qualified to bid for the supply of equipment. And in the annexure so and so, technical committee has considered the workings so and so differently in respect to
Where are you reading?
page.
The complaint is by so and so proprietor, Amar Refrigerator.
Lordship have excluded.
Don't. Yes, we have this.
Yes.
Don't be in a hurry, Mr. It's only we are
Yes, sir.
hearing.
So the first observation is that so and so is the manufacturer. Technical evaluation committee has treated the said firm as authorized dealer. That is not personal. Then Lordship may see in the annexure so that your Lordship may ignore the response. Third point your Lordship may see. As per the qualification criteria mentioned in the tender document, attested copy of VAT registration and certificate of VAT clearance for last 3 financial years issued by the concerned authority be furnished. As per the so and so was expected to furnish the VAT certificate for so and so, but firm has not submitted VAT clearance certificate for so and so, therefore was not qualified in the technical bit. Then your Lordships will see. Further, the technical evaluation committee said firm is eligible firm to award contract without verifying the VAT clearance certificate by relying on false affidavit dated. Then not technical evaluation is only not with the criteria. And so and so is a distributor and not manufacturer. I can go on and on. This really more very clearly says that process may see next page 107, 109. last paragraph. As per Transparency Act, if the value of the tender is 1 crore, the tender has to be published in the state bulletin, state tender bulletin, but so and so has not sent the tender notice for publishing the same in the state tender. These are not the lapses of the officials who are involved in this tender meeting. Then the next lapse, 180. The sanction of purchase, sanction purchase of tools, equipment, accessories required each industrial training so and so is bestowed with power of 20 lakhs. Accordingly, 28 items interest value of 5 crores could have been purchased under the tender, but sanction was accorded for supply of 10 crores. Therefore, the financial power not properly exercised. Then documents uploaded by the bidders along with the tender document is not properly verified to ascertain whether they are prepared as per the conditions of the tender and whether tenderers are having technical eligibility, and further so and so was a manufacturer, but firm was considered as an authorized representative, even though so and so who shown as manufacturer was also authorized dealer. Years of supply and verified. The investigation officer has found the following persons guilty of committing the dereliction of duty, so and so, so and so. And lastly, my lord, lordship may see the observations. Since the comments of the above mentioned persons need to be considered as prescribed under section 9 of the Karnataka Local Act, if approved, the comments may be required. Then, my lord, lordship may see all the comments are, my lord, the statements of these individuals are already taken. Lordship may see 120, page 120. Other statements that are recorded. The second paragraph I am reading on page 1. Sorry, 112. I'm sorry, 112. 112. Respondent numbers 1, 3, and 6 in the comments have denied they have not committed any irregularity of the election. The material available on record, which clearly discloses dereliction of duty committed by the respondents in evaluating. So, reply given by 1, 3 to 6 cannot be accepted since report of the investigating officer and materials collected during the investigation clearly discloses the illegality and dereliction of duty committed by respondents as detailed in paragraph 55. A report under section 12(3) of the Lokayukta may be sent to the competent authority. This is, my lord, a detailed. Now, page 125. This, my lord, is a closure report. After finding and recording the findings, so finding your first paragraph itself. Lokayukta, after going through the record pointed out, that explanations offered by 1, 2, 3 to 6 is not considered for putting up note number 58. Now kindly see your note number 58, which I read with your lordships at 112. They are considered in paragraph 2. I read with your lordship. Respondent in second paragraph 110. Respondent numbers 1, 3 to 6 in their comments have denied the irregularities of the investigating officer and have stated that they have not committed any so and so. In view of the material available on record, clearly discloses dereliction of duty with the respondent. Evaluating tender document, even because cannot be accepted. But the closure report of further scrutiny, page 125 says their statements were not considered. And therefore, they go on to close the report at page 128. Reading with your lordship. Page 1. After considering the reply given by respondents and material law, first they say that this was not considered, whereas it is clear that those technical lapses pointed out by the investigating officer are found in the evaluation of tender document. No financial loss was caused to the government. On the other hand, members of the tender evaluation have saved money, saved significant amount of money to the government. Tactics adopted by afterward makes it abundantly clear that they have not approached local access with good faith. Now, my respectful submission is kindly now see the lapses. These are not, my lord, merely commercial realized on the annual of commercial or loss. Go to the root of the matter. Page 107. Say that yes, These are all lapses, but ultimately it has not resulted to the. Now, if we see the first lapse itself, so and so is a manufacturer. The first lapse. So and so is a manufacturer, but the technical evaluation committee has treated the firm as authorized dealer. Therefore, firm has technically qualified to bid for the so and so. In annexures to the tender document, technical evaluation committee has considered wording so and so they differently in respect of different bidders. Then, Lord, most important, VAT clearance is not obtained as per the qualification criteria mentioned in tender document attested so and so. VAT clearance with the last 3 financial years issued by concerned authority should be furnished. As per the set criteria, so and so was expected to furnish VAT clearance for the year, but firm has not submitted VAT clearance certificate for the so and so. Therefore, it was not qualified in the technical bid. The technical evaluation committee considered the said firm as eligible firm to avoid the conflict without verifying the VAT clearance certificate by relying on a false affidavit. They created and also at page 109, you will see how each officer responsible for preparing these is responsible is clearly elucidated. Now, one second respondent being senior officer was expected to verify. Not 9. Report submitted by technical evaluation to find out whether the report of the statement were prepared as per the tender guidelines or not, and whether the tenderers proposed by the committee were having technical eligibility by verifying. But second respondent has not done so. Then Director Information Publicity had written a letter dated so to publish the tender in a daily newspaper as per KTTP Act so. The copy of the tender notice should have been sent to the bulletin officer, but it was not done so. Since the value of the tender was 1 crore, the tender was not published by the state, published in the state tender bulletin, but second respondent did not send the tender to the tender bulletin officer for publishing same in the state tender bulletin. The Lord Investigation Officer has found following directions on the part of first respondent to the commissioner. As per the Transparency Act, the value of the tender is more than 1 crore. The tender has not been published in the state. Not sent so and so. The sanction of purchase of tools. I am reading the next page. To sanction purchase of tools, equipments, and accessories required, each industrial training center commissioner of training is bestowed with power of 20 lakhs at a time. According to 28 ITI centers in so 5 crore, 5.6 crore could have been purchased under the tender, but sanction was accorded for supply of tools of equipment of 10 crores 54 lakhs 19,001. Therefore, financial power. So these are not, there are other irregularities. They have found following officers. Now, Lord, even I presume that if I presume even worse against that, Lord, they have closed the report after taking statements. Kindly see, Lord, no application. Page 128, your Lord. Just say, no application. What was that report? Honorable Lokai for kind orders. It's approved and signed. This was not even given to me. There is a mandate law under section 9. 9 law of the Lokai that the complaint if rejected has to be given to me. This was not given. I obtained under RTI and after the 2 years. That is not one aspect. Kindly see your section 9(6)(d). In any case, where the local is not to entertain a complaint or to discontinue any investigation in respect of a complaint, he shall record his reasons, therefore, and communicate the same to the complainant and the public servant concerned. Here, my Lord, Lordship saw judgment. In the further scrutiny, no reasons approved and signed. So this is a clear violation. It's also not This is strong burden cast on local. So why the earlier report is not? The completely diametrical views.
No, 9(6) says Lokayukt has to record his reasons. We thought that we will support the petitioner saying that we will conduct an. We were about to tell him that you need not labor. The Lokayukta council is very proactive and he will agree that yes, inquiry should be held. Lighter side, Mr. Enjoy the humor. Yes, yes, go ahead. So how do you meet this this thing that no reasons recorded for closing the complaint? We wish that such sort of a facility is available for us also. So somebody would prepare a note and we will say approved, signed. No need to write judgment, right? Lighter, Mr. Yes, go ahead. So what judgment? You are saying judgment, right? What judgment? That he can write. Approval of note amounts to assigning reason, recording reasons, right? What is it? Judgment, Mr. You will have. Right now, when will you have that? He has argued the petition finally now. When will you? You know, how do you, but in earlier this thing, he has pointed out scrutiny note, these are the lapses, these persons are responsible. How do you get over by simply saying note approved? So he should have removed E also. That's what he wants, that not approved. Note approved. This both. Yes. Yes.
In a report sent by your technical people who evaluated that's requirements. You mentioned it because we were these
No, whatever was found in this scrutiny note has been met here. Whatever was found. Whatever was found, has it been met? And are you satisfied that no irregularity was done and everything is in order?
satisfaction is so much that
No, he's a manufacturer, but technical evaluation committee has authorized dealer. What about VAT clearance?
that is what is stated here.
No, he has VAT clearance for 3 years. Where is it said? Where is 3 crore saved? Where? 27.
This is covered here. The complaint
Yes.
is makes it covered here. The other two, here. Get the entire order.
Dated rate doesn't mean that the authority should accept his tender. You could have still rejected, right? Saying that, no, this is exorbitant, we will not accept. Tender accepting authority has discretion, right? That doesn't mean that if his complaint is entertained, it will amount to giving him tender. No. Supposing if he would have been the only person, then also the the authority had the discretion to refuse and to scrap that. He would have filed a petition saying that I'm the only eligible person, tender should be. That doesn't mean that you will ignore lapses by saying that he would have been granted. So therefore 3 crores, therefore they are justified in granting it to a person who is ineligible. How these 1 minute. He is arguing effectively on your behalf also. That's why we are putting him a question that supposing if the authority accepts, I mean, his tender alone would have been there. It was not obligatory on the part of the authority to accept, right? So it has ultimately that it could have said that no, inflated rates we will not purchase. These very reason which you are giving could have been given by the authority and his tender could have been rejected. Right? No, but you tell us, Mr. I mean, that these scrutiny note at page 107, several lapses have been found. So where is it that you are satisfied subsequently that these lapses did not exist? No, so tell us one by one, where does it say that it is, he is a authorized dealer? Ah. That's not the ground. That's not the ground that these, the complaint in respect of which he has made this officer, so they are not concerned with the decision-making process. That's not what it is. So how have you arrived at this scrutiny note then? The Mr. Against whom you take action, that's a different thing. We are not on that. But in scrutiny note, you have found, right? 1, 2, 3, whatever. 6. We will hear. Huh?
The explanation offered by those officials has been rejected. That also is clear. Page 1.
One minute. Hey, Mr. No order will be passed without hearing you. He is arguing. We are asking him question.
The officials has given a explanation that he requested, saying that it's not satisfied.
Explanation given by these people have been rejected. Page 112. No. So I mean, what is the basis for over? Mr. Who is the responsible? That's a different thing. But the fact that there have been lapses has been found in the scrutiny note by your officer only. How do you then subsequently, how there is a change of heart? That's the mystery. What material? No. So where is that finding recorded that everything NS Engineering Works is an authorized dealer? Then this thing, he has a VAT registration certificate for 3 financial years. No. So obviously, there is no this thing explanation with regard to these lapses. You have only said that they have acted in such a manner as would have saved 3 crores. Therefore, no necessary, no need. And Mr. Page, come to page 112. 112. Right? No. Yes. No item wise apart from that 112. Read respondents number 1 to 3. 1, 3. Have denied. This is also approved by Lokayuk. Honorable Lokayuk for kind order signed. Put up PSN next page. 113. I mean, that's what we see. Signed means it is approved. And then again, now he approves. No, they 113 signed, right? Oh, whatever it is, but the fact remains. No, but assistant registrar, your whatever inquiries has found out, right? That's what he has done, right? He agrees to the note, whatever is put up. So presumption is that this note was put up, he must have agreed. So, so what is the basis for like taking a different view from to a, so you are saying there is no point-wise thing. So then how only that here they have saved 3 crores, out of which this authority must have received some crores who has accepted the tender. So that's the ground. Where is it? Please, I mean, we don't think the question is so difficult that you are looking at us. No, 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 no. No, some. No, in the scrutiny note, point number 1, 2, 3, 4, 5, 6, they have been found, right? There are 6 deficiencies have been found. In addition, just a minute. Just a minute. In addition, the finding is recorded by assistant registrar inquiries that just a minute. Explanation, and these 6 officers are responsible. And then he has recorded a finding that just a minute. Listen, Mr. First listen. And thereafter, he has said that the explanation cannot be submitted. Now, on a report submitted by another officer, he Lokayukta agrees. So, where is that? How these 6 points and the fact that the explanation was not found to be satisfactory have been dealt with? The simple thing we are asking you. Not approved. Even. No, these are not findings. No. Array, Mr. Death, whosoever, inquiry officer, we are saying, but he has pointed out 6 deficiencies. So where those efficiencies, they have, Lokayukta has found that it has not been done. He has not done anything. He has only written approved. He doesn't know what is approved. What is approved? No, Mr. What is, we have understood, right? But in a prima facie inquiry sort of thing, prima facie scrutiny stage, when 6 deficiencies have been found out, right? And it has been said that these officers are responsible and their explanation is not satisfactory. So now they have been asked to give the reply. So you tell us that these points have been found to be incorrect in the subsequent inquiry after consideration of their reply. No. We now come to page whatever is approved according to you. Page further scrutiny. Further scrutiny note now. Page. Where is it? He says that he is not a manufacturer, whatever. That's what we are asking. That NS Engineering Work is a authorized dealer. Where is it? Not there. Then annexure to the tender different. Then as qualification criteria, VAT registration certificate for should be furnished. Has he furnished? Not there. This is what we are saying, Mr. So answer is simple, right? Not there. Technical evaluation committee has wrongly evaluated. So where have you said that it is rightly evaluated? Where is that? Who has considered? Same person. Same assistant. Just a minute. We want to know same officer, assistant registrar, inquiry. Same. So these people have met them separately, it appears that privately. That's what we were told by Mr. Shetty in one of the cases. That if you meet the officers privately, their perspective changes. So assistant registrar inquiry is the same person. Same. How he has changed, then still, I mean, same person finding it and same person. He has put up the note, right? He has not done anything approved, he has said. So still the burden is more on the, in that case. How very same person finds out, how very same person says, no, nothing is done. Everything is there. This thing, everything is done in accordance with law. That's what we are asking. Now, in the subsequent note, further scrutiny note, that very officer finds out, no, everything is in accordance with law. Because you are relying on his reasons, right? Because Lokayukt has not done anything. He has only said approved. No, first tell us, this is the basis, right? Supposing if this order is passed by Lokayukt, let's assume this order as it is, because he has said approved. So where is it that this all is done in accordance? No, it is, Mr. The second scrutiny report is more about the conduct of the complainant. Instead of focusing that he has been trying to grab the order and all that, this all written here. And 3 crores and profiteering. He being a businessman is entitled to profit whatever he wants. You can reject his tender saying that it is not obligatory for us to accept his tender. You, an authority, as an authority, can reject his tender. So, like you can reject, like if you are an authority, you can reject his tender. But what is this? I mean, where is this? Yes. So therefore, everything depends on the opinion of the assistant registrar, right? He decides what to do. He decides what to do. He has decided not to take action. It has been approved. That's it. What application? We don't know why you are contesting. You should have said that if this court feels, we will conduct a further inquiry. Simple. Had I been a counsel for, you are defending the order means like that you are out to defend these people. Hey, you are a statutory body, right? I mean, you are this thing. How does it matter if we ask you to conduct an inquiry? You could have said that if your lordship feels, we will conduct a further inquiry. What's there? Of course. Hey, it will not be concluded. We told you the order will not be passed without hearing. So why are you getting agitated? Please argue now. That's all. That we will decide, Mr. You have argued that it's application of mind, very well reasoned order. You are opposing the prayer. It should be dismissed with cost of 50,000. We will record that. Yes. Yes. Please. Who are you? Who are you? Who are you? 328. Who you don't want to us to hold an inquiry? Yes.
record. We will not. The report submitted would be on. After that, other entity. That can be.
They will always obviously issue notice. Otherwise, yes, yes.
For that, it's notification. For the they offer expression from the concerned point. After the receipt of the explanation, they will make it studio final whether it should go for and that inquiry out. At time of what is the case, did not disclose the detailed hearing. What was happened? Tender will not hear. So there will not for the there. Thanks for the call. That's on the training law. They have their own already. But if not going to tender. That's what we then appeal after. We did not go. We not about the thing to go back. The local authority is not about the tender. Committee law. And even we did not the committee as a part.
We will, Mr. Arbati, you need to respond. That's the submission.
Probably Arbati. Probably Arbati wants to hold it. Hold it.
Further, no, and second, tender property. He came after. These are not.
Yes. You are below tendering. Tell us. No, he said that, right? You are not above him.
No authority.
Does not call for any reply. We thought that, my lord said that you may have changed. My lord said that you may have changed your mind and now you want to hold an inquiry. Below. So that means, so law provides him various forums what to do. Law provides him the right to file an appeal, to make a complaint. He has exercised. What can be done? That we know under that Transparency Act. He can file an appeal against the order of the authority to to an appellate authority. So merely because he has not filed an appeal, his complaint cannot be dismissed, right? That we have understood. But Lokayukta also doesn't say that he has not filed an appeal, therefore the complaint is being dismissed. That's true. That's it. Yes. Nick. 1 minute. He is there. What happened?
Next.
Objections filed. Yes, Mr. Ramesh. Ah. Ah. No, this petition is confined only for implementation, right? Ah. Yes, you are ready. You don't want to file any rejoinder. What a mint prayer. Seeking to revive a dead thing, right? What?
Reduce the number of seats in radio diagnostic seats. It was allotted from 10 seats to 9 seats. Which is below the.
So you filed a fresh petition, what amended to duly? Then argue, then if you have raised the ground, then argue. You are ready, right? Take it up. Take break.
May I submit, my lord, one thing? My lord. The next matter, my lord, 49, just a week's time, my lord, I require, because I am held up in another matter, my lord, I have to argue an old matter. Next week, I request your lordship. 49th matter, my lord.
So next week he's saying. Learned 1 minute. Learned counsel for parties jointly pray for adjournment. List in the next one. This is 49.
49, there are 3 matters, my lord, altogether.
All 3 matters, all of them.
Yes, yes.
And he says that it's covered. We don't know in your favor or against you.
No, it may be, my lord, COWARD also.
Acha, okay. Yes. Let's see what 130. Why? So what were you doing at PG courses? What were you doing? Sleeping? No, what you tell us when the cause of action is agreed. Today at 1:30.
Meeting this month.
18th November. So today is what did you do?
Today evening is the last.
So what difference does it make? The quantum of fee makes any difference? You choose between one of them. Let him, you sit down. Let him speak. No, that doesn't mean that we have to give them notice. That doesn't mean that you should be allotted and made President of India. No, nothing. No. Tomorrow it will come up. No means what? Who will hear? You can't hear. You hear and pass an order and give it to him. No means what? No means what? No means what? You said no. No means what? Who will say no? We have that power of saying no. You don't have. So then you said no. What does it mean no? No. This is the question of means what? What does it mean? You will come anytime. You go to Honorable the Chief Justice. No. 18th, what have you done from 18th till Today is 23rd. So then why did you not file the petition on 22nd? Why did you not file it on 22nd? And why at 1:34, now 34 minutes past 1, and you are saying that it should be heard? Why? Let them.
Almost 300 kilometers
Nothing.
from back. And the server of their bank was not working properly. That was the issue. But payment is made. Just because alert.
We will see to it. You supply him a copy, it will come up tomorrow. Nothing. Mr. Ramesh, you seek the copy and from him, you supply him a copy, Mr. And seek instructions, we will take it up tomorrow. This all.
ஏந்துட்டாரு ஒன்றும் மென்ஷன் பண்ணல கவனம் பண்ணிட்டா ஓகேண்ணா சும்மா வருது வருது அப்படியே
Sir, court officer, sir. Sir, court officer, sir. Hello?
see your face and all that. High Court of Karnataka, and if they find that you are doing something wrong, they take you away from home. Keep it closed. Because it's risky for you.
I just unmuted it.
ದಯವಿಟ್ಟು ಹೊರಗೋಗ್ಬೋದು ಅರ್ಧ ಗಂಟೆ ಮಿನಿಮಮ್ ಬೇಕು ನನಗೆ ಅವ್ರಿಗೆ
patient இருக்கானே ಇಲ್ಲ 45 தான் வரும்.
One case is going on after this. Not mention when the motion hearing is over. And you have this habit of mentioning at 4:20 what can be done. Yes. $15.10.
Which one was the question I got the last seat.
So what now? What's your grievance then?
Subsequent to that.
You don't want in MD radio diagnosis. That,
That was.
so how have you lost it now?
I lost that seat.
You don't know. Obviously, it has to be that you cannot blame like this, right? I mean, that it is required to, that decision was accepted by government, they have done it. So whatever it is, supposing if you succeed in this petition, some other candidate cannot come that this court passed an order, I lost my seat. What is this? Don't discuss. That order has not been challenged by anybody. It is, you did not challenge that I lost my seat. So then there's no, like, where is that order, Mr. Quota, 15 to 20%. Date of order, WP number. 20512 of 22, decided on last page of that order. And as from 15 to 20%. So then again, the counseling was done afresh.
C category as it's then 3%. C
From 10 to 9.
10 to 9.
So
There are a total of 60.
when it was reduced, when? A means when?
31st.
31st?
First.
Reduced. So what did you do?
30% allotment was made immediately. On the very same instance, first round was reconducted. Allotments were made. I did not.
When?
I did not get anything.
When was first round held?
31st.
So seat matrix was notified on 31st.
And my option entry, the last day, my option was 31st. Allotment was made on 6th.
You said 31st. It was all right. So yes. So then.
It's third. Ordinance.
When did your representation? What representation? like for allotment of a seat. Allotment of seat. Representation for allotment of a seat, right? Acha. Implementation of that what is the group?
And consequences. Kindly implement the ordinance for hand. One of us. Second ground also that they have reduced the seats. There are a total of 65 radio diagnosis seats. Radiology MD radiology seats under the government quota. Out of 65 seats, 50% becomes 10 seats. We have 45 9 seats under the SC category, reducing one, which I had got earlier. The very
So
last seat.
they should redo the counseling again.
Fine.
That's it. Yes, Mr. Ravi.
There. Yes, okay.
Ah. What notification? So it has been made effective from? That is the prayer that the benefit of ordinance should be given to him.
This in my object. Very nice. Yes. The ordinance is not coming. Wherever. Right there. There have to refix. Yes. That goes and it comes for second round of complete came to end of 16th of 11th.
Second round 16-11. And mop up from 23rd. 23rd.
Government connection R2 and that you would pick the both points. Which are the increase in reservation. Appointments.
What is it? 1711. What is it?
That's it. Admission. Wherever the admission.
So, and what is the explanation for reduction of seats for SC category from 10 to 9? No, but no. First round it was 10, right? First round for scheduled caste was 10. And then second round you have reduced it to 9. Why?
So then, what's the what?
Our total number of seats were 65, right?
17% is reserved for SC. Sixty 65 seats means 17%, it has to be 10 only.
So
65 seats means how much is the 17%? How many seats? Now it is 17%. It has come into effect from 111. Annexure R only the R1, the last line. Annexure R1 last line you read. It will annexure R1 last line. Section R1 says it will not apply if the admissions are over.
ಈಕೆ ಮೊಬೈಲ್ ಹಾಕೊಂಡ್ಮ కొంచెం అయ్యి ఇలా కదు ప్రాతికో.
What does this last sentence mean? ಈಗಾಗಲೇ ಪ್ರವೇಶ ಪ್ರಕ್ರಿಯೆ ಪೂರ್ಣಗೊಂಡಿದ್ದಲ್ಲಿ ಅಂತ complete. Admission ಪೂರ್ಣಗೊಂಡಿದ್ದಲ್ಲಿ it has to be completed. Was it over by 111?
31st.
First round.
No, first.
That is the first round. First round was over. That's it. Therefore, the entire process is not over. Therefore, the process which remains after 111, this could be applicable. Above.
Two two 158. So the candidates who have been admitted are more meritorious than you. No? Yes, they have given the ranks also. No, no, 20780 or 2215158. But the fact remains, also fact remains that the persons who have been admitted are more meritorious than you, as on today. Right? It's a simple question. We don't understand. I mean, this question, the question is very simple. The candidates who have been admitted are more meritorious. The answer is obviously yes. It can't be no. You are trying to answer it by saying something else. But the fact is that you have scored 27,000, you have secured 27,844 rank, and these persons are above you. That's what we are asking.
Last seat, that was what. And we are. But we see. Yeah, they will have.
That's it. Thank you. Which case, Mr.? This one? 46. 46. Not interested in arguing, right? Yes. You will also not answer simple questions like him, right? The representation not made to the state government. Was it made? Again, the same question. Not made, that's it. Then we can understand any further submission that it was not required to be made and all that. But factually, you should not tell lie on facts. We don't appreciate and we remember such advocates who make wrong submissions on facts. Right? So I mean, it's not made, not made. What can you do? You are not being sent to jail in co-op petitioner. So why should you tell a lie that it is made and which is capable of being verified from the record that it's incorrect statement? Not made. Burden is on you. That's what my lord yesterday also asked you. Where is that representation? Not here. Now that argument we understand that it is not required to be made. That we can understand. Right? You should be, I mean, you have a long way to go. Right? Go ahead. What? We are only emphasizing, don't make incorrect factual submissions. Be fair to the court, irrespective of the result. If the petition is dismissed, you will not go to jail. Simple. Right? Yes. 1 minute. 1 minute. Please wait. Yes. We take up within 5 minutes. Yes. Oh. This petition. In this petition, the petitioner inter alia seeks a writ of mandamus to respondents 1 to 3 to implement the provisions of Karnataka scheduled caste and scheduled tribes within bracket reservation of seats in educational institutions and of appointments or posts in services under the state within bracket close under the state bracket close ordinance 2022 and to re-notify the seat matrix for PG NEET 2022 examination. The petitioner also seeks a writ of mandamus to respondents 1 to 3 to reserve 17% of the total seats under the government quota for scheduled caste candidates and to conduct the counseling for postgraduate medical seats in PG NEET 2022 afresh paragraph. Facts giving rise to filing of this appeal. A petition. Facts paragraph where facts giving rise to filing of this appeal. Petition briefly stated are that the petitioner was appeared in the PG NEET examination and had secured a rank of secured a rank of 27,844. The petitioner participated in the first round of counseling, which was held on 15/10/2022, and was allotted a seat in MD Radio Diagnostics in the first round of counseling. Full stop. In the aforesaid round of counseling, the quota in respect of in-service candidates was fixed at 15%. Full stop. The aforesaid reduction of quota was challenged by in-service doctors in a writ petition, namely WP number 20512/2022, which was decided by a bench of which was decided by this court, and the reduction of quota from 30% to 15% was for in-service candidates. What was quashed? The matter was, however, the state government was granted the liberty to prescribe the quota for in-service candidates afresh, while taking into account the relevant criteria and to fill up the seats. Paragraph. The state government, in compliance of the order passed, aforesaid judgment passed by this court, prescribed the quota for in-service candidates from 15% to prescribed the quota for in-service candidates as 20%. And fresh round of counseling was held, full stop. The seat matrix was published on 31/10/2022, and the counseling and the first round of counseling on first round of counseling was held on 31/10/2022. Full stop. The petitioner participated in the first round of counseling. However, she was not allotted the seat. In the aforesaid factual background, the petitioner has approached this court. Paragraph. Learned counsel for the petitioner submitted that an ordinance was promulgated on 23/10/2022, by which the quota for scheduled caste candidates was enhanced from 15% to 17%. The petitioner, after promulgation of the ordinance and after promulgation of ordinance and after participating in the first round of counseling, submitted a representation on 2/11/2022 for implementation of the ordinance. It is further submitted that instead of implementing the ordinance, the state government has reduced the quota for candidates belonging to the scheduled caste from 10 to 9. It is further submitted that a direction be issued to the respondents to implement the ordinance and to redo the counseling. Paragraph. On the other hand, learned government advocate has submitted that the ordinance dated 23/10/2022 has been made effective with effect from 1/11/2022 and does not apply to cases where the seat matrix has already been notified. It is also submitted that the seat matrix in the instant case was prescribed on 31/10/2022, and the first round of counseling was over by 31st of October 2022. It is further submitted that thereafter the second round of counseling has already been held on 16/11/2022, and mop-up round has already been mop-up round would be concluded today, that is on 23/11/2022. Full stop. It is also submitted that while enhancing the reservation for in-service candidates from 15% to 20%, the seat in scheduled caste seats reserved for scheduled caste category appears to have been reduced from 10 to 9. It is however pointed out that more meritorious candidates than the petitioner, namely the candidates who have secured ranking of 20780 and a rank of 22158 have been admitted, whereas the petitioner has secured a rank of 27,844. Full stop. It is also pointed out that no interference in the matter. It is therefore contended that no interference in the matter is called for at this point of time. Paragraph. We have considered the submission made by learned counsel for the parties and have perused the record. Full stop. Section 1 within bracket 2 of the ordinance. Ordinance provides that it shall come into force on such date as the government may by notification appoint, and different dates may be appointed for different provisions of the ordinance. In exercise of power under section 1 within bracket 2 of the ordinance, the state government has issued a notification dated 15/11/2022. Has issued an notification. Date. No notification dated 15/11/2022. Has issued a notification by which a notification dated 31/10/2022 by which the date of commencement of the ordinance has been prescribed as 1/11/2022. It is also submitted that the state government by an order dated 15/11/2022 has it is prescribed the date, full stop. It is pertinent to note that in the instant case, the seat matrix was prescribed on 31/10/2022 and the first round of counseling was held on 31/10/2022. Full stop. The petitioner therefore cannot seek the benefit of the ordinance in the instant case. It is also noteworthy that by an order dated 15/11/2022, the state government has provided that the benefit of ordinance shall not apply in cases where the admission process has already commenced. Paragraph. Has already concluded. Paragraph. Full stop. The full stop. The full stop. In compliance of the directions issued by this court in WP number so and so, compliance of direction contained in the judgment dated so and so issued by this court in so and so, comma, the quota for in-service candidates was prescribed for quota for in-service candidates was enhanced from 15% to 20%. Full stop. In view of the directions issued by this court, it was inevitable for the state government to redo the exercise. Thereupon, the seat matrix was provided afresh on 31/10/2022, and the quota for scheduled caste candidates was reduced from seats there was reduced from 10 to 9. To stop. In any case, comma, in any case, more meritorious candidates than the petitioner have been admitted to the PG course. Full stop. No, the process of admission is already complete. Therefore, at this point of time, no interference at the instance of the petitioner is called for in the process of admission, especially in the absence of the candidates who would be affected by the decision which may be made by this court. Paragraph for the aforementioned reasons we do not find any merit. This petition saved bills and is hereby dismissed. Yeah. (17)(2). Yes. Yes. With the detailing authority. Record. What are your instructions, Mister? You can't like, it was made to the government. What have you said in your petition? Any other petition? And
ये जीटी कोर ट्रिक मार्क्स पैसा
them, Mr. What stated to members of the Board of Attention. Passing the confirmation order number 393. It would be remain to class. The same shall be as early as possible be considered for the appropriate government before sending the papers to the advisory board. The appropriate government revokes the detention order and directs the release of detainee who arises of the advisory board. Within 3 weeks, page number 47.
Any order. For reasons that was either directly submitted to very good or they later after one anything. Dated 6 May, central advisable to the supervisor. It clearly indicates that the state government failed to consider the admitted for the advisory. We are officer of the rank of District Commissioner of Police. Saying so we cannot plead ignorance about the knowledge of the representation made by the police. Paragraph 14. Knowledge about the representation from 6 May 2020. Though it was approved, cannot plead ignorance about the representation. Therefore, the case of Timothy Gracie is fairly accurate. Since this violation of the right conferred upon the prisoner detainee on the class 5 of Article 22 of the Constitution. Therefore, continuation of 23/3/2022 itself, beginning of the endorsement date. Knowledge of they cannot read any ignorance. Petition number 39 of 2020. Of the judgment that the duty the representative has to be exercised at the delay in considering the representation will constitute a ground to nullify the order of conviction. What is the earliest point of time is essentially subject to and settled principle being that the representation has to be considered at the earliest point of time and presentation being considered by the state government so that much time has been effective. That's it. That's for that, answer that.
In the record,
You have prepared a list of dates and synopsis. In that you have mentioned about the representation given to the government and as well as the representation given to the advisory board.
Later, he came to the entire and
There is a mention about the representation being given to the advisory board as well as to the government. It's prepared by you.
If it is the fact, then I have little case. That is the case.
See, you have,
that is the case.
therefore, the documents are not very clean. This paper they have forgotten to remove. All papers are removed, but this is not removed, unfortunately. That is marked. Why it has to be given to the advisory board for transfer? Transfer it can be given to the jail authority or to the.
Now given it, and those are also available.
You show us that. No. You show us that.
Available. And that's the.
Show us that. The document which was given to the advisory board for transfer.
To the representation.
Advisory board ಗೆ ಕೊಟ್ಟಿರೋದು ತೋರಿಸಿ for transfer. Then there is a representation to advisory board. What is that? See the index, mister. There is mention there. No. That we cannot believe. It's your file, mister.
Does not accept this.
Cannot be.
The documents are not there.
No. That is the original file. It's your index. Index says that document is there. That document is not found in the. We have to draw an adverse inference against you.
So it's not there. Yeah. Not there. There will be one. That government.
How do you explain this?
to advise what it's. But both the materials will not be there with us. Material is independent, that he has to say whether he has given.
No, it is in your file. You have made a note of that. How can you say that you do not know? No.
That's the reason probably they become more.
This is mentioned after the, that is mentioned after filing of the writ petition. Therefore, it is not that it was mentioned at the time of participating in the advisory board. It is mentioned after filing of the writ petition. Advisory meeting was held on 21. This is given on 22, next day.
Get the further into the jail of such a representative. Not because it was in jail. This is the government file. Maintain the government. And will not may not be necessary. Only the jail of.
What info?
What instructions, Mr. You are producing the record from there, it is, then.
Period.
It is found in your file. Yes,
Then-
it is found in your file. You have prepared a synopsis after the writ petition is filed.
My lord, only draft and
Whatever it is, unless that document is there, why should that, it should find a place there?
there are not officially. Otherwise,
This is unofficial, right?
we don't not use mail. Draft or some copies that we taking the.
Mr.
Maybe a mistake.
You have produced the record and then you are saying like this, who will believe?
See, whatever is there.
Take action.
There is anything, whatever there. I cannot.
What information jail authorities will give you now? But
They will write down the register. From that register, we come to know because you will not be there that the register was also summoned. And we came to know that the representation was given. That is not
No,
there.
what is your explanation? File an affidavit. Who has prepared it and that is incorrect. Then the question of making further inquiry arises. It's your record. Please appreciate this. You have to explain. If you are prepared to explain by filing an affidavit that such and such person of our department with a view to help petitioner has wrongly prepared this, we will take action and we will then we will grant you further time to verify. No, Mr. Such a thing, it's there, right? It's there. How you are arguing? I mean, this your record. Lordship has said that you have produced it. It shows. How can you argue that it is incorrect now? Without, I mean, orally saying. You should let him file an. No, not orally.
and also let you find out from the
File an affidavit that is incorrect. Please file an affidavit. If this is according to you is incorrect. Oral submissions won't, I mean. Please file an affidavit.
The jail authority. And maybe that statement.
That this.
Maybe a mistake also, don't know. The government said they. Then we want to. If such a representation given, then my submission will go on what?
No. What is the reason not to believe your record? Tell us. There is a presumption in favor of record.
Drafts also. Wherein they copy thing, that is the happened now. That is, they keep whatever they draft and all. Finally, they give the final draft to us. That is the. In this also, whenever in government record, sometimes they keep the drafts also.
Saying
And if
anything.
it fails, draft will be there. That also they keep in the original record. That's the their record, not the usual. Sometimes drafts are also. That is the reason. Maybe a draft and they might have.
Mister, it's a serious issue. Please, we cannot entertain this oral submission. You will have to file an affidavit. Who has kept the draft? Who has not signed it? Who has done it with a view to help the petitioner? You will have to take an action. Things will not stop like this. Otherwise, we will have to stop believing the government record also, which you are producing. So then, I mean, you make up your mind. I mean, file an affidavit, then the matter will be taken to its logical conclusion.
Yes.
We will not stop at that. You will have to, we will take it to its logical conclusion, but you tell us whether you intend to file the affidavit. That is all incorrect. The record which you have produced has been tampered by somebody. Or whatever. I mean, we don't know whatever it is. That somebody has inserted the draft. Why he would mention an incorrect date, Mr. Draft also? If it's not there, that shows.
May not sometimes incorrect draft.
Oh.
Then they correct it because higher ups.
Draft means.
And this.
Also, draft means incorrect things have to be necessarily stated. Then only it can be corrected.
Not usually.
No, but we are not. I mean, Mr. No, Mr. No, we are not prepared to like this. Can't be. Can't be like this. Let him fight. It's an order of detention dealing with Article 21. We cannot take the casually the way you are dealing with it. That's what. That's what I mean. You are saying. No, you are saying it happens. It happens means it is alarming that a government deals with fundamental rights of such people. No, please file an affidavit. Why you say everything? We will hear. But matter will be taken, Mr. Hegde, to its logical conclusion. You opt, you decide whether you have. We don't know. You are liberty. Hey, we don't know. We don't know, Mr. We don't know. You have produced the record. And we don't know. We don't know. No, you file an affidavit explaining that this is incorrect. Yep. If means what? I mean, what is your submission? You, we will say that we have noticed this and it is shown to you. You are saying it's incorrect, right? And you want to file an affidavit, correct?
Yes, sir. The date mentioned there may not be correct. May not be correct. They are also not going to be represented.
Is there? It is there. It is their specific case that they have not retained the representation. Not given, not retained it. They say we have given it, but we don't have a copy. That is his case.
have having given a representation to the government, he has answered, we have not given any representation to the government, only we have given the representation to the detainee. Therefore, that proposition is not again can be considered. Only thing is whether
No, sir, Mr. No, no, on perusal of the records, sir, something has come to our notice to his advantage. He may not be knowing. He is in jail, right? That person is in jail. He may not be knowing. So, but you have to say that this is incorrect.
that's one thing, but government, that's not for me. There is no clear talk.
There.
You are not doing anything.
Which paragraph? No, no, Mr. Rai. You make up your mind, Mr. Hegde. If you are asking us to decide it today itself, we will do so. Don't argue half-heartedly. Either you decide what is the future course of action, please decide. And then if you are asking us to go through the pleadings and all that, we will pass an order today itself, right? And if you want time to explain, file it. File an affidavit. You are saying that it's incorrect. Para 6. It's there. No, para 6.
The para 24. There. Para 24.
24.
Para 24. State government. Third respondent, he admits, third respondent has considered it. With the state government and advisory board, it has not considered it. That is his case. Cannot be missed. It is dated 21/3. Sent, it has been sent, not personally given. Anyhow, your records speak the truth. Therefore, it is for you to explain now.
Explain means you have to file an affidavit that this is incorrect. And that record will be with us. Give it. Keep it, Mr. in a seal cover sort of thing. You are saying that it's incorrect. You are saying it's incorrect, right? You are saying it's incorrect.
Dates.
No, dates.
That is the.
How do they then? How do you maintain the record? This saying that it is made, and why should we disbelieve? We don't know. You have given it to us, Mr. I mean, so are you not, as an officer of the court, are you not responsible? Just handing over anything to court. And supposing if we would not have noticed that, then why should we not disbelieve? You just hand over anything like containing draft.
I have to
We will allow. Article 21 serious thing. He cannot get away by justifying anything like filing an affidavit. This is Article 21, Mr. Seriously. No. You are not inclined, but he says so. He has submitted a representation. Your record shows that it was submitted and it has not been decided. End of the matter. Why we should go into, you should be more cautious henceforth and ask your officers to maintain the record. What is this?
Got it, sir. Corrected copies also there. Therefore,
we
it
don't-
may be a draft. Mentally incorrect. Here also is there. I can do it in the order. This is the draft. The second one is the payroll. The draft also they have kept it. And it is numbered. They cannot change it. It's all numbered. And this particular document, what? Now it is there. It's not even numbered and not even second.
But if the
No,
cost
are you
plus-
saying that this is not part of the record and inserted by the petitioner in your record? Is it your case?
No.
What?
I think
But that sheet has got a cost title. That,
That is right.
therefore it is prepared in this case.
prepared in this case.
By the petitioner and kept in their file. Serious issue.
That is not telling. And that is verified by the officer. That's the reason.
Let it be go into this what sort of record they maintain. We'll have to take cognizance and comment on the way they are producing documents before the High Court.
Fairness. There's no fairness in that.
Huh? They can't do like this. All right, we'll take the matter to its logical conclusion. You file an affidavit, whatever. Be cautious, and the matter will be taken to its logical, including you are inviting our comments on the way the records are produced before the High Court, the way your officers maintain. All this will go in the order. Right? The way you are producing draft, this thing and everything, and you are telling us that it's draft. Whatever stand.
We have whatever they have given it, we have produced it because it's all numbered.
Whatever I will. Yes.
Can tamper with the government record. Whatever it is there, I have produced.
No, that record itself shows that he has submitted a representation. Your record, you are saying, now you are saying, if you are saying it's a government record, that record itself shows that he had submitted a representation which was not considered. Why it should not be quashed, then tell us. The order has to go. Yes, actually means you are. No, we are telling you, it's your add-on.
Yes.
Oh. Sure.
File affidavit, we'll give it tomorrow. let him
Ten.
We'll list it tomorrow if you want to file an affidavit.
He's in jail. Mister. What is this? Without this thing is Article 21. No, this thing. But tomorrow you file the affidavit.
Record will keep it in the record will take it.
Record, take it back. Give back the records. Note down. In this repetition, comma, The petitioner inter alia seeks a writ of certiorari for quashment of order of detention dated 10th of February 2022. 10th of February 2022. Paragraph. Learned counsel for the petitioner during course of his submissions argued that even though he had submitted a representation to the state government, however, the same was not decided and therefore the order of detention is vitiated in law. Full stop. In support. Paragraph. In support, learned SPP or PP, whatever, has produced the records pertaining to detention of the petitioner. The records indicate that the petitioner, the records indicate that petitioner records the record produced by learned edition of learned SPP or whatever PP contains a list of dates and synopsis which show that the detainee had submitted his representation to the advisory board, which was received by the government on 18/5/2022.
Advisory board received on 22/3.
Which was submitted to the submitted advisory board, which was received by the board on 22/3/2022 and by the state government on 18/5/2022. Full stop. Paragraph. When a query was put to learned SPP, PP, whatever, PP, he prays for adjournment to enable him to file an affidavit. This is the advocate for respondents. He has prepared it for you. He files learned so and so prays for adjournment to enable him to file an affidavit explaining the aforesaid dates which have been mentioned in the list of dates and synopsis. List tomorrow. You have done your so difficult. Article 21. They are giving it an utmost priority, right? Not everybody else is waiting and we are taking up your case. But don't go anywhere. Nothing will happen. Learn to sacrifice for your clients.
Afterwards, you leave it. Afterwards, you leave it.
Serial number 47, I beg to appear for respondent number 2, my lords.
After 10 years, still, I mean, that will take another 10 years for senior counsel to come. This what? This is nothing. senior counsel. Preliminary notification, final notification under KIADB Act. channel. Yes, Mr. Griffin. Yes. Yes. Please give.
It appears to have received 1%, and others notice has not been issued. Some confusion is there, I will not make more. If there is no award, amount has not been paid. Therefore, our main contention, award not passed. The amount has not been paid. Therefore, the opposition is initiated. First contention. This question appears to have been referred to the report. Yes.
Order by full bench.
Pending before.
Hmm?
Pending before.
Pending before. Then
I think it can come to next week. We won't be able to this.
no, so it could be await the. No, there is already a reference. What is there? No, not.
This question is this, whether
Ah.
acquisition proceeding initiated under the
No, where?
at 1958.
Where are you reading, Mr.? 28.
Banks that are initiated to the trade activity which is not completed and compensation is not paid to the land user within the reasonable time. This is the question. Because there are three rules are there. And therefore,
No, but we have writ appeal. I think we have.
refer to the three digit please see the first two, which is already pending. Reference order is recorded in this.
So in your case, what has Learned Single Judge done? Ah. Ah.
Award has not been passed.
Fine.
Could be solution, the order not being taken, will be contained. Don't take it.
Ah.
And third, the land was acquired for the purpose of industrial area. The land is industrial estate. Therefore, the two distinct things, there is information with the content. Therefore, I am not going into the discussion. Second one, the industrial area. Only they have industrial area. And but the award is the award in possession is something there is no clear finding. That you have challenged the police now with the we are accepting the submission. And what is that? Actually, no, this land was not the records restored. They go there to the land. Some here, it was transferred to some other person, some other industry. And there also it was and the after 28.4, not 128.4 is restricted, that is it. Movement. The fact remains that they have to take possession from us. 28.5 is very clear. Therefore, my acceptance submission is not, the possession has not been taken. They have not passed the award at all. Therefore, this on the report made at the time of submission, directed them to produce the records. And on verifying the records, there is, this is, despite the several 2 decades of expired, they have not developed the land at all. You will know that it is a vacant land, completely vacant, and no industry has come up. No, the award has not been passed, and the award has also not been taken. Therefore, the submission, this is the having regard to the fact that the object acquisition has not been achieved, and acquisition itself is vitiated, is made acceptable. Because they cannot acquire the land and keep it for themselves. Sometimes they have to use the government. Ultimately, they must have an object first. It will not self-escape. And they have to play a specific scheme. For what purpose they are acquiring the land? It is for the industry. For all these things have to be made, at least they have to pay. Nothing is restricted. So now, the Learned Single Judge, they have made a false statement even, saying that we have already found the layout. This is what they have made. They will not play, para 7, 108 para 7. It is humbly submitted that the land in question and other lands referred to above are acquired for public purpose and establishment of industrial area in the state of Karnataka and generally to promote the establishment and orderly development of industries in the state of Karnataka. The possession of the land in question, along with other land, was taken on 21/10/2006. There, second respondent to very powerful. But 208, they say that they have developed. Nothing has been done. It is as it is even today. Therefore, my respective submission is, it is clear of misleading. This was the and it's, can we take this? You know, the fact that already. I have also given what are the ground, I will not remember. Okay. And the order to order have written this order in WP, page 7. What is it? Then there are 4 lines for them. We are concerned about 2 items, that is 136 bar 2, 106 bar 4. Yes, that we also accept that. And the third one is under the one of the one has signed a statement stating that please give this land to me because I have no other property, and give this land to me is the statement he has filed that was rejected by the officer. Fourth one is possession was taken on. What was it made by the authority because possession was not taken. No document has been issued before. Award was passed for the award was taken. And then when the industrial area and industrial will not be, the large extent is acquired and they develop the. Here is the case, they say it is approved. So the notifications of industrial area allotted to one industry. And they have not done successive transfer assignments, have not done anything. Details. I have 4 details. It says that the 8th SHLCC, there is a state high level committee meeting held on 23. First. approved. The government has accorded approval for execution of the project proposal by subsidiary company of Measures High Speed Development Private Limited, government order dated 22/5/2007. I humbly subscribe that possession of 191 acres guntas was taken over by the special LAO Mysore on 21/10/2006. I humbly say that the first responding areas allotted the land and issued possession certificate of different dates. Allotment letters 29/3/2007. Three allotment letters, different dates. Then the lease cum sale agreement was dated on 12/6/2007 itself. The supplementary agreement was executed. Then it was registered thereafter. But the Para 9, from Para 9 of this agreement, very clear, Para 9 onwards, in page 4, if you have dated 8/7/30. Second respondent, small term provision, this affidavit was filed on 6/7/2013. And they say the second respondent has put up a small term provision and erected compound wall on northern boundary, only one boundary, put up barbed wire fencing in the part of the some portion kept vacant. One tiled roof building existed. They have not submitted building plan for approval to the KADB so far. Even plan was not produced in 7 years. But then, when you say that it is not adhered some sale agreement, hence KADB will initiate resumption proceedings under section 34B of the KAD Act, and then further action will be taken in accordance with law. This is the first affidavit they have filed. And also, the photographs are all. Nothing is there. No construction. Vacant. You don't have to fight for 7 years. You will today it is lying. So therefore, this is one. Then the second, the court was not satisfied. They have directed them to file further affidavit. Again, they filed another affidavit. That is on 12/7/2013. Then we got to the notice of December, nothing has been done. They have not taken any action. Court directed them what action you have taken. Then they produced certain documents of 2013, 2013 documents to show that they issued a show cause notice, presumption of the land. Thereafter, nothing has been done. Only issued show cause notice and they have kept quiet. This is the second affidavit. And the third affidavit also on 18/7/2013. Here also they say they have not given the compensation because we have not accepted. This is their contention. We failed to accept consent award. But their first contention is they have taken possession. Consent award we are agreeable for 9 lakh per acre. That's what they have stated in the objection statement. But we said we want the land for ourselves. We are not taking any compensation. The award has also not been. What they are saying is we are going to pass an award because they are refused to take the compensation. Till date, they have not passed an award. Therefore, my respectful submission is having the award to be painstaking by them for decades, 2 decades, and the not having paid the amount, I am a landowner. My right has to be protected because ultimately I must get compensation or I must get back my land. Either of the two. No, but the present situation is ultimately this the court comes to the conclusion. Suppose even some of the one of the matters the court has taken that view. The large extent of land was acquired. Some small portion in between that is left out. Development cannot be. In that situation, the award is not passed. And the compensation is not. Or you are not paying compensation. You pay the dedicated. Very respectful submission. Here our land is on the territory of their extent. And the amount compensation they have, admittedly they have not. Also the employer by case and after all that we have been considering. Unfortunate that it is just that is the reason why last year because of the controversies in three employer by case. First judgment was held to be in.
Yes, that's. Yes.
Either I must get compensated or I must get back on the land. But the last statement of this law, either I must get compensated or I must get back on the land. That itself shows this is conflict. But on possession, but I don't want to dilate further in the light of this statement. Second is not.
You will know cultivating. Reason is, but the ultimate objective and the acquisition of the land. I'm sorry, I have not highlighted because one sentence is sufficient to be written. That's why I have not necessary to say argue about together saying that I am the owner and I want to get property article 300 days protection. Go the name. If the state were to acquire them, pay compensation, appropriate compensation in time, within the reasonable period. If you don't want the pay the revenue, you pay finance. That is what I meant. That they have taken to this year.
Again, this is you back on that. You have got one purpose. He himself has said there is a shed, not much developed, but if you look at his own petition brought by him. If you are looking at page 30 of his petition of benefit answer page 20. Please come to page 30, para 2 and he says nothing is developed but after acquisition by the. In fact, his statement in paragraph 2 is page 30. First respondent here in the acquired several lands in and around Mogerahalli, Nagarhalli, Virapatnam, neighboring land of the that with the first respondent is in the clear development board. And then the petition came to know that the land is lower, therefore this land is not checked, he knows about And he says, but he did not receive any notice. The letter is false from the original. Says that he has suppressed the letter. I point out. Second, he says, it is something the land decision as what probably what Petition did not erase it in paragraph. It is only in the month of May when the construction of compound was started coming in the land. It is required in the neighboring law. Not that the person. Please come to God page 112. What will he gives a letter. English translation is page 124. He says, Lord, I did not receive any notice. Actually, Lord, he suppresses this fact. Nevertheless, Lord, get that at page 124. English translation at 124. I received a notice of from your office on 4/1 and have seen the contents of the same. Your officer will inform that you have no intention to acquire the land that belongs to us. Mention that you have submitted our objection. We have an objection to your office notice, so. Then Lord, please turn the page. He says, don't take possession of the land. He says, Lord, on the ground. Why, Lord, I mentioned this? His first contention was, he was never notified of the Lord after the criminal notification. That is, Lord, actually incorrect. He suppresses this fact. And learned single judge in the course of the order has noticed this. Also, the original records. From page 17, 17. Second unnumbered paragraph that page 117. Learned also the petition power content the market order was not has not signed the signature on are not such a content also cannot be accepted. This court has compared the signature of found in the Bakal along with it. With the signatures found they are the same. Even by the naked eye, any reasonable person can learn it. The signatures found in the next and the signatures found in the Bakal right along the same. That is Madegoda. That is the text contains the petition that notice were not served in the moreover, Degoda, no Kempegoda, other petitions 1, 2, and 4, and further so as himself filed statement of objections as per class 3 on 27 to the preliminary notification. He has prayed for division of the land. And Lord, the other court, after 3 years, Lord, he has filed 390. 4 years are not coming at why there is no explanation for the delay of 3 years. And Lord, my learned friend today will not contain. That Lord, I have already not, we have already submitted one compilation statement. Earlier, Lord, page number 4 of the judgment. That is 1997 Karnataka law journal number 410. Ninth order of this day. There is what is called even for a single do not unique do not permission to acquire that. It's 37 do not 9. 7 do not was the contention raised by the other side. That is not the line. 9 and page 30. And we deal with industry only more than one industry. Or even a single industry. That is because ideal thing. So one of the arguments is for industrial estate, not for industry or the industry.
Ah, yes.
Questions could not be general for consideration is set out in paragraph. One. That one argument we are not taking. Please come to that page. On the top part, sorry, it's small letter. It's on paragraph 37. Acquisition for a single company, but that is permissible for the owners. Similar to what Justice Thakur is. Similar to what days before the office. The next submission that has been made is the person to whom we have given is not utilizing it. But we give it to not for an industry. If he does not want the utility, even if he does not utilize, but we take it back and use it. But when I still not going to pay 86, 2003, 1 year 6335, 886. Paragraph 12 of this statement. At running page 91. Paragraph 12, page 91. If the land was not used for the purpose for which it was required, you will go to the state government to take action. And did not confer any trade. That's why. But it is that the northern Indian glass industry. Sorry, but it didn't take it. My apologies. Northern glass. It not got B and paragraph 12, but can I request you to paragraph 12? Paragraph 12 of this. The land was not used for the purpose for which it was required. You go to the state government to take action. That did not confer any right. Already know state government is regarded as already receiving. In fact, we are not taking money. We will not allot it this very land. You will not high speed. Please come safely to not be a place before your office. Please come to not running place 48. There will be
211 of the volume 1.
Make 14. 3911. Page 49 supplementary. Annexure D.
Annexure D.
1. 3911.
What's not line number 6 line. High street developer private. It is allotted, executed agreement in their favor. and over possession and record my in front of their some sheds and all. Industry will not be always being shed.
Small shed.
Part is fast, composition,
When was the award passed? No, award. Yes.
98, okay, CC 287, 83. I have 21. Page 67, my last with that. And not get. Right, not more than 3 years. But once got the land less, and got 28, 5, and it not this year. On public and it's the best absolutely. Yes, or not be. Even not the. Are 34. 35. And again, they say about the AD Act is a self-contained code. I'm not right, but the act is finally a law regulating. It's not a lot of the land. That's what 35.
But still it has to be done within a reasonable time, even if 11A does not apply. That's the argument.
My submission is not interest submission. Therefore, interest, even if they're not, there is a delay, interest not the. As far as what 28 days concerned, but question of taxing would not arise. Vesting. That's the difference. I agree with your lordship. Difference between the land acquisition act and the KDB act. Is a vesting job. That's what I understand.
Yes, madam.
My lords, for respondent number 2. Lords, my personal presence may be excused. I'm slightly under the weather, my lords. I may be permitted to submit on VC. Just a few additional points, my lords, because some allegations have been made in the writ appeal against me as well. As a learned senior counsel already pointed out, my lords, the possession has been given and I have paid valid consideration all the way back in 2007. I have provided the lease deed as well at Annexure P of my objections. Over 10 crores has been paid by me and possession has been taken over by me. This ground as to lapsing of the award due to passage of time, my lords, a lapsing of the acquisition has not been raised in the writ petition at any stage, because the writ petition, my lords, was filed in the year 2009, which was 2 years after I took possession. At that time, my lords, they have not said that there is a lapse of time, there is a delay. In fact, to the contrary, the delay is on their account after participating and writing to the authorities under the acquisition proceedings. From 2012, a writ petition is kept pending before this honorable court. And today, an allegation is made against me saying that the property is not developed. I have, of course, my lords, filed a very detailed affidavit as well on the last occasion before this honorable court, that a total of 231 acres was to be acquired in order to notify that as an SEZ, out of which 109 acres has been given to me on lease. Now, in order to develop this as an SEZ, my lords, the entire acquisition has to be complete so that we can reap the benefits of an SEZ. Apart from that, my lords, we have faced access issues, khata transfer issues, and of course, other litigations around which the KIDB is also cooperating in removing. So there is a bona fide attempt to develop this area for the benefit of the state. And there has been no delay on our part. We have certain unfortunate circumstances where there are litigations, etc., which are causing delay apart from access issues and acquisitions. But otherwise, there has been a concerted effort, my lords, and I have filed a detailed affidavit as to why there is only one shed as they are alleging. But certainly there's been on far more progress, if not visibly there on the land, my lords. In addition, my lords, just a few points. An allegation has been made that I am a fictitious company. If my colleague in court may be permitted to just file the latest ROC extract to show that I'm an active company. I think these are just allegations made that I am not an active company, or bona fide allegations are made that there is collusion without any support, my lords, only to counter that to say that we are made that there is collusion without any support, my lords, only to counter that to say that we are a bona fide company, in fact, belonging to the Shapoorji Pallonji group. And there is a genuine effort being made. We've paid consideration as well. Those are the only additional points, my lords. Apart from one fact, my lords, in the writ petition, no objections have been filed by me because I have not been served. That also I have placed on record before this honorable court as to how a wrong address of mine was provided in the writ petition and I was not served. Only when the KIDB came to do a survey did I become aware, and I have participated in the proceedings in the writ appeal. Apart from that, my lords, on the same lines as I won't repeat anything that the learned senior counsel has submitted, we've also filed a case compilation, my lords, on 19th of July, 2021. A large part of it overlaps, my lords, with what the KIDB has filed, so I will not trouble my lords. The only additional case laws I would have submitted, my lords, is on allegations of collusion that cannot be made lightly.
Yes.
I'm deeply obliged, my lords.
Nobody else has done. Everybody has acted. And that is the overwhelming 99.99% of the people are accepted. They will not the entire
We'll hear you tomorrow. All right. List tomorrow for further hearing. What do you want? Why? You are appearing for respondent. Donate counsel for the applicant praise for it then. List after 2 weeks. This 2013 matter, this year it should be decided, right? So why should you seek adjournment? Tomorrow we will see. You have partnered. We will see tomorrow. Can any of your colleague can mention, right? If you are stuck up somewhere.